Okay, good morning, everybody. My name is Judge Kim Teresa Malika. You're in First Appearance Magistrate Court. Today you're going to be informed of the charges and we're going to determine if there's probable cause. Today is not your trial day. Please do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney. We have a public defender, I believe Mr. Romero, in the main jail, and we have Mr. Reedy, who's here in the courtroom with me. If you have a private attorney, please let me know when you step up to the podium. We'll be back in one moment. We're just pulling some cases. We're going to take some cases at a turn. Thank you. right, let's call Mr. Mendez, and then confinement, we'll get to the other cases, okay?
No problem. Thank you.
Great. All right, we're gonna call a case out of turn. You said page 24, sir?
That's what I was told, Your Honor, yes. Mark Eiglosh on behalf of Mr. Mendez.
Okay, Juan Pablo Mendez, please. Is there a Juan Pablo Mendez? He's on page 24 of the docket. Here he comes. Okay. Good morning, sir. Are you Juan Pablo Mendez? Have to hit the button, sir.
Yes.
All right, thank you, sir. All right, counsel, if you can announce your appearance for the record.
Mark Eiglosh on behalf of Juan Pablo Mendez.
Thank you. All right, state, announce your appearance for the record.
Eric Linder on behalf of the state.
Doreen Monk on behalf of the state.
All right. Do you waive formal reading?
I do, Your Honor.
Okay. Sir, we have to talk about bond in your case. Your attorney has waived formal reading of the charges. State.
Your Honor, I'm still reading through the report. I don't know if counsel has any information he wants to provide to the court.
All right, do you want to recall this case so you could speak to him a little bit more? I don't have a problem
Sure,
with
that's
that.
fine.
All right, so we'll just recall it. And we'll
I
take a
appreciate
couple
that.
other
Thank you,
cases.
Judge.
Let me know when you're ready. All right, Gregory Patrick Ferrara, please. What page, Devin, if you could tell me?
Page 25.
Page 25, thank you.
Possessions.
No, that's, thank you. Okay, are you Gregory Patrick Ferrara, sir?
Yes, ma'am.
All right, sir, you have possession of harmful new legend drug without prescription, and this is page 25 of the docket, by the way.
This.
Bond is set at $25. Count 2, possession of a harmful new legend drug without a prescription. $25 bond. Count 3 is petty theft, first degree, between $100 to $300. $100 bond. Count 4 is using anti-shoplifting control device countermeasure, $1,000 bond. And count 5 is possession of hydrocodone, which is also Vicodin or Zione, $1,000 bond. Any objection to probable cause? Okay, court does find probable cause. Anybody want to be heard with regard to the $2,150 in bond? Go ahead, Mr. Romero.
Yes, Judge, good morning.
Good morning.
Speaking of Ferreira, right now, from what he advised me, there's no one that could go ahead and post his monetary bond. He is currently working. He obtained employment at a meat market. He's a cook. He's been there for approximately 2 weeks. He makes $13 an hour.
Okay.
In North Miami. He lives in an apartment by himself. His rent is about $850 per month. Judge, my understanding from what he advised me, there's no one that, like I said, that could post his monetary bond, and he's not in a financial position to post his own monetary bond. So therefore, I'd be asking you at this time, considering these are all nonviolent offenses, I'd be asking you to consider releasing Mr. Ferreira on standard pretrial release. I know today's not holiday. From what he did inform me, he has a valid prescription. He had the prescription
All
filled
right,
at
let's see
Walgreens.
if the state agrees or disagrees. Do you have any objection to pretrial release?
Yes, Your Honor.
That's what bonds are kept in place.
The state would ask that the bond be kept in place.
All right, go ahead, Mr. Romero.
Judge, like I said, as far as in reference, some of these are drug offenses. From speaking to Mr. Ferreira, he did get these prescribed to him. I did tell him that once he gets released, he filled out an application for public defender. He would need to go ahead and forward that prescription to our office so we can send it to case file, and hopefully those cases would go away. Judge, I know you said you found probable cause. I haven't had an opportunity to review the probable cause affidavit. I know on count 4, the anti-shoplifting control device, I know you're quite familiar with that statute. I don't know if the alleged item that was in his possession, or the police are saying was in his possession, I don't know if it was specifically designed to defeat some sort of anti-shoplifting device, but if it wasn't, I would ask you to take that into account for mitigation purposes, and once again, renew our request to have him released on standard pretrial release.
Hey, state, what's his priors?
He's out right now. He's out on pretrial diversion.
Your Honor, he's out on pretrial diversion from a Miami-Dade case, 2 separate cases for retail theft.
And out of Massachusetts.
And out of Massachusetts, he has a 2017 larceny over $250, two separate cases, a 2018 assault and battery, 2015 for the record, and a 2013 larceny greater than $250, a 2009 breaking and entering.
Okay, is his address, Mr. Romero, 2727 Indian Creek Drive, Miami Beach?
I ID officer, but I
Yes,
give
it's
the
Dave.
right address. Because I use the address that's on my ID.
Okay. That's not your mailing address.
That's, I have to do with the new address that I described.
Okay.
That's the address that I use on my ID.
Do you have the new address on North Reading? Okay. Can you please say,
300 Northwest 47th Street, Miami.
is that a house or apartment?
It's a house.
Okay, and what's the zip code in Miami?
I just looked at it, I don't know the address. I think it's 33127.
Judge, is 300 Northwest 47th Street in Miami, Florida? He's unsure as far as the zip code.
That's not a problem. They auto-populated, like I said yesterday. All right, so this is what the court's gonna do. Can he afford any bond?
I mean, I don't get paid till Friday, but I had no one to cash the check. I just bought it. It's funny. I just bought a TV, and I spent all my money just 2 days ago.
So the answer is no.
No.
Ferrara.
No, he can't.
Okay, this is what the court's gonna do. The court's gonna ROR him on each charge. However, court's gonna put him on standard pretrial release. You have to explain to him, Mr. Romero, that he has to report within 24 hours, and that if he gets another charge, he's most likely gonna be violated and sit in jail. Okay?
Judge, I'll give him the map right now. Sir, you're gonna be released today?
Okay, Omar, pay red, please.
Don't
Oh, no,
report,
wait.
you're gonna get arrested. Go.
He on here?
Who's the next person you're calling, Judge?
Hold on, I'm trying to go in order.
Yes, Judge.
Next one is Brian Gargis, page
That's you?
13.
Oh, 13.
Yes.
Mr. Brian Vargas, you're not him, right? Yes. Call my name. Okay, then have a seat.
Is there a Brian? It's Gargis. Good morning, sir. How are you? Good morning, sir. You have 2 KPS traffics. You're going before your division judge, sir. Judge Lerner Wren, Division MT, April 23rd, which is this Monday at 2 p.m. Bond set at $250 per charge. Charges are leaving the scene of an accident and leaving an accident unattended vehicle. Total bond is $500. Thank you, sir. Good luck to you.
Judge, Mr. Vargas is asking me to ask the court if you would consider resolving the case today for time served?
Not for leaving a scene of an accident, sorry.
Yes, Judge, I understand. Good luck,
Okay.
sir.
And then the next one is Chris Hilker, please, page 12 of the docket. Thank you.
Chris Salter, he's here, Judge, it's a municipal. Oh, good morning, hey, how are you? Good morning, Anna, how are you?
Good. How are you, Mr. McLawrence?
Judge, I'm fine.
Do you want us to recall this? Are you ready? Want us to recall it, or are you ready?
Judge, I'm ready. I'm not sure how ready Mr. Hilker is.
Okay. You want me just to pass it for a moment, or you want me to wait? It doesn't matter.
Judge, he's here, Judge, and I think the staff here at the jail want to move through his case and figure out what we're going to be doing.
Okay. So come on up, Mr. Hilker. Okay, is that him?
Yes, Judge.
All right. All right, we're unfortunately, I don't think he's in any shape to proceed with the hearing. I mean, unless you want me to go forward with it. Do you want me to
No, Judge,
reset it for the PM or tomorrow, or
No,
transfer it to
Judge, I
Judge
think-
Wren?
I think if you set it for tomorrow, we'll be fine. I don't think it's a Judge Wren issue.
Okay, thank
it's
you.
I think it's a detox issue.
Okay. All right. All right, so what we'll do is, we'll reset this for 4:19. I'm sorry, 4:20 tomorrow in the AM.
Judge, I have the appointment form with me, so I'll bring that up when I come up to
Sure,
your
no
court.
problem. Thank you.
Judge, I have Arthur Daniels. He's on page 16 of the docket.
How many others do you have?
Okay.
Judge, that's it. It's just, Mr.
All right, let me
was on
pull
page
him
12.
fast. Page, what's his name? Arthur Daniels?
Yes, Judge. He's on page 16. He has a city case for count 1, and he has a felony case for count 2.
All right, hold on. Okay, I have him. Okay. All right, Arthur Daniels. Is that your name, sir?
Yes, ma'am.
All right, good morning, sir. You have a KPS misdemeanor, $100 bond. He does have a KPS felony. He has a no bond hold for possession of cocaine. He also has, which is, he has an open container, a no-show at arraignment KPS, $100 bond. He is going before his division judge, Judge Melinda Brown, on 4/26, which is a week from today at 10 a.m. Anybody want to be heard?
Yes, Your Honor. In speaking with Mr. Daniels, what he indicates to me is that at the time that he had the hearing, or whatever it is that he had on those cases, he was actually in custody in Miami-Dade County. Obviously I can't check that from here. I'm not sure if Eric would be able to check that or not. But if that's so, I was going to ask you, Judge, if you would resolve count 1, which is the open container, which he wants to resolve, and if you could ROR him possibly on the felony possession of cocaine case, if in fact he was in custody in Dade County when he was supposed to be in court.
It's Judge Barbara McCarthy, so we're going to have to reset this for the afternoon then to look into it.
Okay, Judge, and that'll give me some time to pull up whatever it is I need to pull up, and I can get it over to Hector.
Okay, so let's reset to PM. Thank you.
Okay, thank you, Judge.
All right,
Wait,
we're going to
Judge,
go.
wait, what do you want to do on the open container? Can you resolve that?
I can resolve it if you want to, as long as he knows that it might affect as a felony case.
No, you won't. It's not gonna affect the fact. Okay, good. Okay. Judge, it would have a, if anything, it might have a 0.2 point effect on the felony case, which isn't gonna do anything, and I've discussed that with Mr. Daniels, and he wants to resolve it.
All right, let me ask you this, Mr. McLaurin. Are you saying for the KPS misdemeanor for the open container that he was in Dade County as well?
Yes, Judge.
All right, so why don't we just wait for this afternoon? Are you going to be back anyway? So.
Okay.
All right, thank you. All right, let's take the next case they want to take. So this is reset for PM. Okay, next one is
You don't read.
Larry Nystrom, Larry J. Nystrom. That is on page 11 of the docket.
Mr. Nystrom is here present, Judge?
Okay, Mr. Nystrom, you have a possession of cannabis, 20 grams or less, $100 bond. Court does find probable cause. Anybody want to be heard?
Judge, I'm going to ask you to consider releasing Mr. Nystrom ROR. This is a possession of cannabis offense.
Can he afford the $100 bond?
He can't afford any.
He doesn't have any money in property.
Do you have any money in property? Yes or no?
No, ma'am.
Okay, state. They want a straight ROR. Any objection?
But should be aware, he got out of prison about a couple years ago. He's been to prison numerous times. Just so Mr. Nystrom's aware, the state's offered to be a withholding court cost if he wanted to resolve it.
He's shaking his head yes, Mr. Romero.
If that's what Mr. Nystrom wants us to do, Judge.
Okay. Sir, is that what you want to do?
Yes, ma'am.
All right, raise your right hand. Do you swear and or affirm to tell the truth?
All truth and nothing but the truth.
All right, thank you. Is your name Larry J. Nystrom, Nystrom?
Yes, ma'am.
All right, you can put your hand down. It's my understanding you wish to waive your right to a trial, sir?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
Medication.
Okay. Does your medication that you're on affect your ability to understand what's going on here today, sir?
No, ma'am.
Ever been treated for a mental illness?
Yes, ma'am.
All right, does your mental illness, you don't have to tell me what it is, affect your ability to understand what's going on here today, sir?
Yes, ma'am.
It does affect your ability to understand what's
No,
going
it
on?
doesn't.
Okay. You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States?
Ma'am, I've been a United States citizen since I was born.
Okay, so the answer is yes?
Yes.
How do you plead to possession of cannabis, 20 grams or less, sir?
How do you plead, sir?
Guilty, not
Guilty.
guilty? Okay, court's gonna accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court is gonna withhold adjudication and impose court costs, which are mandatory $308. Court will take judicial notice of the time that he served in the Broward County Jail. Thank you, sir. Good luck to you. You're done with this case. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you. Next one's gonna be Omar Payret, page 12.
Mr. Payret, come on up, please.
All right, Mr. Payret, good morning, sir. You have count 1, trespass, failure to leave property upon order by owner, $25 bond. Counts 2, 3, and 4 are capious misdemeanors for $500 each, $1,525. You are going before your division judge. However, I don't have a date it says to be set in your division. Court's also going to find probable cause. And the court's going to order, sir, no return to 408 Lawn Acre Court, Hollywood, Florida. Do you understand?
Yes. Yeah.
And you're also to have no victim contact, direct or indirect, with the alleged victim in this case, with the initials J.E.D. Direct or indirect, and I want everybody in the jail to listen up, means no contact, sir, in person, calling, texting, writing, and nothing through social media, and no third-party contact. Do you understand, sir?
I do.
All right.
Judge, excuse me, Mr. Payret, from what he's advised me in reference to, I believe, the 179836 MMKA case, he says he believed he resolved that case already. Is there any way to look into that, see if that case is resolved?
We can reset it and reset it for this afternoon and do that.
Okay, then. I thought Mr. Linder has access to the computer. We can look, take
Okay,
care of it right now. But
well, Mr. Linder's talking to somebody on another case.
Was
So
that the-
Kifa, can you help him? Or
Yes.
somebody?
Was it 9836 and then 10?
Yeah, was it resolved?
Which
It's
case number is it
It's showing
again?
that it's still pending. Was,
oh, it's still pending, shows it? Okay,
Yes.
let me tell him that, Judge. Judge, in that case, Mr. Payret is asking if the court would consider resolving his cases today for time served.
Okay, state, what's your position?
Eric.
He wants an adjudication time served, Eric.
Payret?
He has trespass, failure to leave property,
Yes, I understand.
and then he has capiouses.
Yeah,
And the capiouses are resisting without, petty theft, or trespass.
yeah, Mr. Payret's been through here a lot, Your Honor, so I just need to check his record to see what
Okay.
offer I'm prepared to make.
No problem.
Yeah, the state's offer to resolve all cases would be, Your Honor, 10 days.
10 days Broward County Jail to run concurrent.
No, thank you, Judge.
All right. All right,
Take care, sir.
what do you want to do with the trespass? $25 bond.
No action at this time, Judge.
Okay,
Thank you.
$25. Sir, no return. Thank you. Oh, you know what? right, and then the last one that we're gonna call out of turn for the jail is Michael Tucker, please.
Mr. Tucker, come on up, please. What page is Mr. Tucker on, Judge?
Oh, I'm sorry, page 26 of the docket.
Oh, 26. Oh, okay.
Yeah. Okay, good morning, sir.
Oh, warrants, okay.
How you doing, sir?
Good morning.
Good morning. All right, Mr. Tucker, you have count 1, larceny of a credit card, $100 bond. Count 2 is illegal use of a credit card to obtain goods under $100. There's no bond attached to that. And then counts 3 and 4 are warrant, VOP, via violation of pretrial felony. There's not for magistrate. He has 2 no bond holds. Court does find probable cause. Anybody want to be heard with regard to the $100 bond?
Considering as no bond hold, not at this time, Judge.
$99 bond on count 1. Thank you. All right, so we're gonna recall Chris Hiker. All right, let's start with, do you have a case? Sure.
Is this one of yours, Lawrence Danielle?
I just opened to it.
I'm sorry?
About that, I just opened right to it.
Perfect. I hope
Okay.
that's a good sign.
All right, page 19, folks, Lawrence Daniel, we have a private attorney. Counsel, announce your appearance for the record, please.
Michael Manis on behalf of the Mr. Daniele.
Is that 1 N or 2?
Manis, 1.
Okay. All right, good morning, Mr. Danielle. You have 1 charge of aggravated battery with a deadly weapon. We have your private attorney here, Mr. Manis. State?
One moment.
Any objection to probable cause?
No.
Okay. Court does find probable cause. The court is going to order no victim contact, sir, direct or indirect, with
Judge,
the
I'm sorry, if I may, as far as victim contact, this whole matter arises out of a landlord-tenant dispute, so
Okay,
as long as...
so I'll hold off on it.
Okay, thank you.
You're welcome. Glad you stopped me. All right, sir, hit the button there, please.
She jumped out of the,
Thank you. Okay, perfect, good. Just leave the button off because I get the feedback from the jail. If we need you to say something, then we'll have you hit the button, okay? Thank you.
I'm muting it.
the state would be requesting $15,000 bond and no victim contact.
15, 1-5,
Yes, Your Honor.
okay.
On the victim contact, Judge, maybe if it's just indirect through counsel, because there is going to have to be contact there.
That's fine, Your Honor.
As long as it's through counsel, we have no objection here.
Yeah, when I say third party, I mean no one they know, or it doesn't include counsel at all.
Understood.
Okay. All right, so do you want to be heard with regard to the $15,000 bond, sir?
No, that's fine.
All right, so $15,000 bond, no victim contact, you said, right? Is okay?
That's
All right.
correct, other than through counsel. Just
Yes.
to, okay.
Okay, so sir, no contact, direct or indirect, with the alleged victim with the initials MS. And what that means, sir, is no contact in person, calling, texting, anything on social media, no third-party contact. However, that does not include anything, of course, that your counselor has any type of contact with. So that's it. Thank you.
Thank you, Your Honor.
Thank you.
Your Honor?
Yes, hi.
Hi, thank you so much for passing Juan Mendez. Could you please call that again?
Sure, no problem. All right, let's recall Juan Pablo Mendez. What page is that again?
24, Your Honor.
Okay.
Mark Eiglarsh on his behalf.
EIGLA.
R-S-H.
Okay, thank you. Is it M-A-R-C?
K.
Okay, sorry.
I'll be filing a permanent appearance as well
All right.
in this matter.
I'd just like to note who it is on my magistrate. Thank you, Mr. McLawrence. See you this afternoon. Okay, Juan Pablo Mendez, please.
Your Honor, he went back. We'll bring him back to the courtroom.
Okay. I don't know why they took him back, so when you see him go in there, Deputy, if you could let us know when he comes back, please, I'd appreciate it, thank you. Or Counselor, if you see him there, thanks. Okay, let's start with our regular, unless you have one, Mr. McLaurin.
No, Judge.
Okay. Katie Leonard, please. Katie Leonard. Hello, ma'am, how are you? Are you Katie Leonard? Are you Katie Leonard, ma'am? Good morning. She's not answering me. Is she Katie Leonard?
Yes.
All right, ma'am, you have a out-of-state hold for a felony. It appears to be out of South Carolina. It's for a violation of probation for a financial transaction card. I will see you in extradition court either today or Tuesday at 1 p.m. Thank you. Next one is Angela Marie Amonte, please.
I believe that's North Broward, Judge.
Okay, thank you, Mr. Romero. Okay, Angela Amonte, please.
Just coming, Your Honor.
Good morning, how are you?
Fine, and yourself?
Fine, thanks.
Yeah, but it might not go through. You know, the reception.
Hello, ma'am.
Hi, ma'am.
Is your name Angela Amonte?
Yes, ma'am.
All right, you have a KPS misdemeanor for a petty theft. You are going before your division judge April 25th, which is a week, or it's actually this coming Wednesday at 9 a.m., and that is Judge Cal Evans. There is a KPS for $250. Anybody wish to be heard? She has a no-show with calendar call.
What did he say he was in? Do you know what he said he was in?
2017 in Dade County.
Oh, I'll have to.
Excuse me, Mr. Reedy?
Yes, Your Honor.
If you could give me, we have Angela Maria Monte. She has a KPS misdemeanor for $250. She has a no-show with calendar call. $250 bond.
Would like to resolve this case if possible
That's what
today.
I thought. Okay.
Your Honor, the state's previous offer is 15 days in Broward County Jail based on her criminal history, which includes 2016 felony theft, 2016 felony theft, cocaine 2011, cocaine 09, felony prostitution, resisting without violence 07, year and a day state prison, felony prostitution 07, VOP a year and a day, cocaine 07, trespass 07, heroin, possession of heroin 06,
I'm just looking to see
possession of
if she's
heroin
on
03,
here.
4 charged counts of
see her.
theft 03, grand theft auto, interference with child custody 02, VOP 364 days county jail, theft 02,
Oh, I see her. It's
theft
Isaac
01,
Ramos.
2 counts of grand theft and forgery 98.
Okay, I got it. Okay.
That's it.
Yeah, please. Okay, it's Isaac the Ramos, right?
All right, so what's your offer? I'm sorry. Sorry, how many days?
15 days, no return to, 1 moment. It would be 15 days, Broward County Jail, adjudication, no return to the Walmart in this, involved in this instance.
Okay. Okay, Mr. Reedy? Hold on, ma'am, your attorney's on the phone.
Okay.
All right, this is what we're gonna do, ma'am. Take a seat. We're gonna take a break, okay? Court's gonna be in recess. Yes. She has a prior history that is a little bit extensive. Would you please repeat it for Mr.
Well, you know,
Marie?
Judge, she's been in trouble a lot, as she indicated to me. She's been living in the same location for the last 10 years. She does have some disabilities that prevent her from working. She's been a Florida resident for 27 years now. As I say, she does have family here. If Miss Amati is not agreeable to accepting that offer, I would ask the court to release her on her own recognizance.
Well, I can't do that. It's a capias, and she failed to appear for court.
Well, she doesn't have $250, Judge, and
understand.
I think 15 days on a petty theft is, I don't know if the court can do any better than that.
Okay, the court will give her 7 days Broward County Jail.
Angela, would you take 7 days?
Yes, ma'am.
Okay. All right, that's fine, Judge. She'll
And
take
no
that.
return to the Walmart, ma'am.
All right, don't go anywhere. We're not done.
Okay, ma'am, raise your right hand. Do you swear and/or affirm to tell the truth? It's my understanding, ma'am, you wish to waive your right to a trial?
Yes.
Okay, put your hand down. Your name is Angela Maria Monti, A-M-A-N-T-I.
Yes, ma'am.
Is anyone forcing you to do this? No?
No.
Are you under the influence of any drugs or alcohol?
No.
Ever been treated for a mental illness that would affect your ability to understand what's going on here today?
No.
Are you on any medications that would affect your ability to understand what's going on here
No,
today?
ma'am.
Okay, you understand that if you get another conviction, which my understanding is you have many of these, you can be charged with petty theft, or a misdemeanor can be charged as a felony. Do you understand that?
Yes, ma'am.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings?
Yes, ma'am.
Understanding what I just explained to you, do you want to plead guilty, not guilty, or no contest?
No
Get an-
contest.
Hold on, and get an adjudication and 7 days Broward County Jail with credit for time served
Okay.
for this petty theft.
Okay.
No contest?
Yes, ma'am.
Court's can accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Court's going to adjudicate 7 days Broward County Jail, credit for time served, court costs of $293. No return to Walmart, ma'am. Do you understand where this alleged incident occurred? Thank you. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Next one is Anidia Simone Holland, please.
Just in case Mr. Mendez is back, I don't know if you knew that.
Okay, no, I don't, but let's call
What's your
Anna,
name?
Anadia Holland.
Holland, okay.
Anadia, I'm sorry. Holland, please.
She's here at Main Judge?
All right. Good morning, ma'am. You have trespass, failure to leave property upon order by owner. Court does find probable cause. Bond is set at $25. There's no return to the Embassy Suites at 950 South Ocean Drive, Deerfield Beach, Florida. Do you understand?
Yes, ma'am.
Anybody want to be heard?
Judge, she advised me
Excuse
that
me?
anyone wishes to be heard is what she said.
Oh, I thought she was talking to me, that's why.
No.
She's gonna self-bond, Judge.
Okay. Thank you very much.
Thank you.
What's your name?
Okay, let's call Juan Pablo Mendez. Calling it out of turn, we have Attorney Mark Iglarsh.
Pronounced Iglarsh, thank you,
Iglarsh,
Judge.
I'm sorry.
Mark Iglarsh on behalf of Juan Pablo Mendez. Thank you.
You're welcome.
Judge, I've had a good amount of time to speak to the prosecutor, who's always very fair and reasonable, and I can understand why he is requesting a $25,000 bond based upon the nature of the charge. I just wanted the court to be aware of some additional facts that hopefully will make the court comfortable with a bond that's much less. He doesn't have the financial ability to make that type of bond. My client has lived in South Florida since he came over when he was 9 years of age. So he's been living here, he's 32 now, he's been living here for 23 years in South Florida.
Okay.
And he's never been arrested for anything. In fact, he has led an exemplary life. He served in the Army for 5 years. He did a tour of duty in Iraq. He was honorably discharged. He is happily married to Anna, who I spoke to this morning, who loves him unconditionally and is supporting him. They have a newborn that he supports and an 11-year-old. What makes this case very unique is he wasn't just surprised with the arrest. He had spoken after waiving Miranda and spoke with law enforcement. I don't want to litigate the case. I just want to talk about the facts that show that he would never flee. He knew what was being accused of him. I was retained. I spoke with the detective, and we arranged a surrender for him. If he was ever going to flee, it would have been the time between the time that he had spoken to law enforcement and the time ultimately that we surrendered him. I have emails with Detective Pence where I said he is willing and eager to surrender. And she wrote back 7 p.m. at the Fort Lauderdale Police Department, and he was there on time and ready to zealously defend this case with me. I obviously have no objection to a no contact order with the alleged victim, but I think that he'll be able to make a $7,500 bond. It's just a financial issue, and I'm hoping that that would be sufficient. He's given me every indication that we're going to be defending this all the way through. I've been retained for the long haul, but this is borrowing and pleading with friends. He is unemployed now because Massage Envy saw fit to let him go in spite of the presumption of innocence. So he's fallen on some tough times right now.
Okay, State.
Yes, Your Honor, the state is going to be requesting a $25,000 bond, obviously in order of no victim contact. And Your Honor, the state is also going to be requesting a release condition that Mr. Mendez is not allowed to perform, professionally speaking, a massage to anyone until further order of the court. Your Honor, the state's concern is not necessarily one of flight. It is this safety of the community based on these allegations. Your Honor, I do want to advise the court, and I know counsel, and I imagine this is based on information he was provided. Mr. Mendez has been arrested. He's been arrested twice, once in Dade in 2004, once in Hawaii in 2008. Now, in full candor, those charges were dropped, but I just want the court to know.
What were they?
One was a DUI and reckless driving in Hawaii, and in Aventura, it was for disorderly conduct, possession of a stolen driver's license, or fictitious driver's license, and resisting without violence. But those charges were dropped. I didn't have any intention of bringing them up. I just wanted the court to be aware. Your Honor, and I spoke with Detective Pence also, and she shares the state's concern as far as that he be ordered not to provide massages while the case is pending. Your Honor, and I spoke with counsel, and frankly, the possibility of a GPS was brought up. And my concern there is that, sure, a GPS would let us know where he is. But my greatest concern is that he's not performing massages. And I believe the bond I'm requesting would be the proper deterrent. I don't know that a GPS would assist.
How is it a proper deterrent? I'm just saying. Whether there's and I'm not arguing with you, I'm saying whether there's a $7,500 bond or $25,000, how does that stop someone?
It's the exact argument I made. Yeah.
Your Honor, because the risk, we're talking about collateral that could be lost. We're talking about different amounts. The different amount of money, a greater amount of money is a greater deterrent. Your Honor, the GPS doesn't assist in this matter because while it tells us where he is, if he were to hypothetically put ads online to offer massages from his home, there's no way to know who's going to his home or what he's doing in his home.
I would just add to that, he's been a licensed massage therapist for many years, and in his hundreds, probably thousands, I didn't ask him how many massages he's done over that time, this is the sole complaint he has ever had. I didn't concede to the prosecutor that his condition of release should include him not being able to be a therapist. If the court wants to take that step, court could, but I'm not sure that that's appropriate either. I'm not sure what other way he can earn a living for his family. But again, my important point is to get him out. And a bond of $25,000, the difference between $25,000 and $7,500, nothing as it relates to protecting the community, everything as it relates to his ability to be able to get out. He cannot. This isn't a let's see how low we can go. This is $7,500, maybe $10,000. He'll be able to get the 10% from family and friends who are supporting him.
Okay, the court does have concern about the allegations in here, and I understand, you have defenses. This is what the court's going to do. The court's going to do his bond at $12,500. No victim contact, direct or indirect, sir, with the alleged victim in this case with the initials OL. That means no contact in person, calling, texting, writing, anything on social media, and no third-party contact. And, of course, that doesn't include you, sir, his attorney. You're not allowed to perform any professional massages, GPS level 2. Thank you very much, sir.
Can I just be heard on the GPS?
Sure.
Now that the court has restricted his ability to do massages, which is the only way he's supported his family for years, I don't know what he's going to be doing, whether it be, so he's going to need to be out there looking for work, doing whatever kind of work he can. I'd ask that the court not impose the ankle monitor. It's going to make that logistically almost impossible.
I understand. I could do an open schedule. He's going to have a monitor.
Anything that you can do to increase, and I appreciate that, thank you, Judge, anything to give him the opportunity to work for his family, okay?
Oh, GPS open schedule, thank you.
Thank you, Judge, I appreciate it. Thank you,
Good luck to
State.
you, sir.
Okay.
All right, next one is Merica McCoy. Hello, Mr. Williams, who do you have today?
I'm not sure, I don't see it on the calendar, but I had a client yesterday named Luis Lopez.
I'll look it up.
Merica McCoy, a reset.
Was it a felony? Yeah, they don't. Yeah, I understand. But yeah, absolutely. Take care. Yeah, but the problem they don't. Felony cases are not for. Yeah, they're not for first appearance. They never get brought through here. They just don't get brought through here.
I'm going to go off the record for a moment. My understanding is it's a medical reset, but however, the public defender is going to
I'll waive her appearance, Judge.
All right. All right, so thank you. Bye. Okay. Do you have a case, sir? Okay. All right, Kelly Givens, please.
North Broward, It's a municipal ordinance case. I think Ms. Givens might be interested in resolving the case.
Okay, yesterday we had a medical reset. All right, Kelly Givens,
And you,
is that your name, ma'am?
I don't know if you're able to.
Yes, it's Kelly Givens.
All right, ma'am, you have two municipal ordinances. One is obstruction by solicitation, and the other one is no OSHA vest. You want to resolve,
I don't know, they dropped the OSHA vest thing.
No, not according to my records, ma'am.
Oh,
Okay.
All right, ma'am, let me ask you this. Do you want to, bond is set at $25. Can you afford that?
No, I can't.
All right,
I can't.
court does find probable cause. You want to resolve your case today?
Yes, I do.
Would you agree to go to talk to someone so you don't have to live on the streets, ma'am?
How do you mean?
Well, you were panhandling, correct?
Yes.
All right, so do you have a place to live?
Well, yeah, I kind of do right now. I just found a place to live right before that happened, like a day before.
All right, well, there's this place called Henderson. It's a new project that they have. It's totally voluntary. They only want people that want to go there, and it's a centralized receiving center. And if you want, they can pick you up from the jail, take you there. They just want to speak to you for an hour, and that's it. You can leave at any time. It's a pretty good project that they have, and they can help you with obtaining money and help you with any issues.
No, I don't want to do that, Your Honor. I have a place to stay. I just want to resolve this.
Okay.
And get it.
All right, so this is what the court would do. How many days has she been in jail? It says 416.
I've been here 4 days.
Okay, all right, so the court will adjudicate you, give you 4 days in order no return. If I see you go back there again and you come back here, it's going to be a stiffer penalty. Do you understand?
I understand.
All right, so you want to take 4 days Broward County Jail, credit for time served?
Yes.
All right. Raise your right hand, please.
Yes.
Do you swear and/or affirm to tell the truth?
Yes.
Is your name Kelly Givens, Givens?
Yes, it is.
Okay, put your hand down. It's my understanding you wish to waive your right to an attorney and a trial in these two municipal ordinance charges. Is that correct?
Yes.
Is anyone forcing you to do this?
No.
Are you under the influence of any drugs, alcohol, or medication?
No.
Ever been treated for a mental illness that would affect your ability to understand what's going on here today, ma'am?
No.
You understand that if you're not a U.S. citizen, a plea of discharge could result in deportation proceedings?
Okay. Yeah.
Understanding what I just explained to you, do you want to plead guilty, not guilty, or no contest to...
No contest.
Let me finish because I have to say the charges, okay?
Okay.
It's obstruction by solicitation and no OSHA vest. Guilty, not guilty, or no contest?
No contest.
The court is going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Court's going to adjudicate her and give her 4 days Broward County Jail with credit for time served. The court is going to impose $78 in court costs, which is I'm required to impose by law.
Okay.
Court is going to run the two concurrent, so you should be out today. Luck to you, ma'am. No return.
Okay, thank you.
To the intersection of Atlantic Boulevard, Southwest 26th Ave. You can't panhandle anymore, ma'am. Do you understand?
Yes.
Thank you. Good luck to you.
Thank you.
You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Okay, we're going to go off the record just for one moment. LaQuanisha Bird, please.
North Broward.
Thank you. LaQuanisha Bird, I'm sorry. Ma'am, you have ad charges, counts 10, 11, 12, and 13. They are capious felonies. You're going before your division judge, Judge Elizabeth Shear, April 23rd, which is this Monday, ma'am, at 8:45 a.m. Your bonds are $1,000 on each charge. These are ad counts 2 to 5 and a change of charge to count 1, which is criminal use of personal info for counts 1, 2, 3, 4, 5. Anybody want to be heard?
Your Honor, Ms. Bird indicated to me that her mother is retaining private counsel.
Okay.
She knows the first name is Scott. She does not know the last name. I tried contacting her mother, but her mother's mailbox is full, so I couldn't leave a message or reach her.
All right, so if you could in the future, Mr. Reedy, please do me the favor, let me know when we first call a case if they potentially have private counsel.
Well, I don't know if she does or not. I mean, her attorney that's listed in Odyssey is a public defender.
No, I understand, but I'm just saying if it's an issue, or they do have private counsel. All right, ma'am, do you have a private attorney in this case?
Not yet, but I am going to have one.
Do you want an opportunity to retain a private counsel, or do you want to go ahead and go forward with the services of the public defender today?
No, I want my private attorney.
All right, do you know their name?
I just know Scott.
All right, so what do you suggest, Mr. Reedy? Call her mother again?
Yeah, I can try if she picks up the phone or if she empties her mailbox. I mean, I can't.
My mom is at work right now. She get off at 11 o'clock.
Well, if you want to reset her for this afternoon, I'll try after 11 o'clock.
Okay, no problem. So we'll reset this, ma'am, for the afternoon. In the meantime, see if you can, we begin court at 1 o'clock in the afternoon. So see if you can get a hold of your mother, okay?
So how many ad charges I got, ma'am?
4.
So they added 4 more charges?
They actually added a change of charge, capious ad counts 2 through 5, and then they have a change of charge for count 1.
Right.
So they're all, I have the new charges are criminal use of personal ID info, $1,000 bond on each one, $5,000 bond total. Okay? All right, so let's reset this for the afternoon. Try to get a hold of your mom. Thank you. Next one's going to be Chanique Caprician, please. Does anybody know where she is?
She's approaching.
Thank you. Okay, Ms. Caprician, you have criminal mischief over $1,000. Court does find probable cause. $500 bond. Anybody wish to be heard?
Yes, Judge. One moment, Judge.
Sure. Ma'am, is your address 521 North 7th Street or Northwest 71st Street?
71st Street.
Northwest?
Yes.
Okay. Thank you.
Judge, I'm going to be asking you to consider releasing Ms. Caprician on straight ROR. This is the reason why. My understanding is this is her first arrest ever. She is 19 years old, been living in our community her whole entire life. She's working and going to school. She works at Starbucks. She's been there employed for 1 year, making $9.50 an hour. Besides that, she's a senior at MacArthur High School. Her GPA is 3.5. She did take the SAT. She scored a 980. At this time, she is applying for NSU. At this time, she's waiting for a letter of recommendation. That's what she's working on, and then from there, she'll actually submit the application. She's a registered voter already in Broward County, being 19 years old. Judge, considering at this time, this is her first contact with the criminal justice system, that's the basis of me asking for a straight ROR.
State?
Your Honor, my concern, and I think there should be some supervision. My concern is her mental health, based on the allegations, her own admission that she keyed this person's car because she didn't like his energy and vibe.
Not funny, ma'am.
Judge, I don't want to get into those issues. I mean, What did you say? I'm sorry, Judge.
I said it's not funny. Your client laughed.
I didn't laugh.
She snickered.
I didn't laugh.
Judge, I don't know what happened with the allegations. I don't know what the officers wrote. I'm sure they probably didn't tell her what they wrote on her PC affidavit. I'm just saying, Judge, she's not going to have any sort of contact with this person. This is her first arrest ever in her life. She's 19 years old. She's not a fighter. She's going to come to court. We're asking for a straight ROR. If Your Honor doesn't want a straight ROR, then that's fine. Just leave the standard bond in place. I will contact her mother to help post her bond, but I know her mom is a single mother supporting her two other siblings. So I'm just asking, this is an appropriate case to be raised as an ROR. If not, leave the standard bond in place, Judge.
All right, ma'am, if they have Northwest 71st Terrace. Is it terrace or street?
It's terrace.
It is terrace, okay. All right. And that's Hollywood, right?
Yes.
All right. All right, State, anything further?
No, Judge.
Okay, $500 bond stays in place. Thank you. Tori Marie McKnight, please. Tori Marie McKnight.
Come on up, please.
Okay, Ms. McKnight, count 1, probation violation. You have a no bond hold. Count 2 is larceny.
She just identified she has private. Right now, I didn't know.
Okay. Okay, ma'am, who is your private attorney?
His name is David Garvin. He's in Miami, so I don't know the cases
You know
in Miami,
what?
so
Hold on.
I don't know if I have to be transferred.
Hold on,
to
ma'am.
Miami.
We didn't do no victim contact. Can I have that one back that I just did? Ma'am, have a seat for a moment. I did? Okay. All right, I did do it. All right, Miss McKnight, I'm sorry. I did do no victim contact. All right, Tori Marie McKnight, please. Okay, Miss McKnight, who is your private attorney, ma'am?
Mike's off.
I can't hear you. You have to push the little button, please.
Okay. His name is David Garvin.
Do you have his number? Do you know by heart or?
305-371-8101.
I'm sorry, 305-371.
8101.
Okay, does he know that you've been arrested?
Yes, he does.
Did,
The case is in question. My BOP is in Miami, so I have to be transported, correct?
yes.
Okay.
Okay, great. Okay, all right, ma'am, apparently what happened, you can come in, sir. Apparently what happened is they booked it on your paperwork here in front of me, states that it's a Broward County violation of probation, but it's gonna be corrected to a Dade County violation of probation. So your bond of $125 and $25 on the larceny of a credit card and the petty theft second degree first offense of $25 has been posted. So would you still like us to contact your attorney?
So then how did he just get?
I guess, but when do I get transported? I don't get transported to Dade for the BOP or something? I don't know.
As soon as we're done today, I will send a teletype to Miami and let them know that she's ready to be picked up.
Did you hear that, ma'am?
Okay.
You heard that?
Did she hear me?
Yes.
Okay, so you'll probably go to Dade County pretty soon, okay? Thank you. All right. Sharan Shepherd, please. Sharan Shepherd.
It's a medical reset?
Yes, medical reset.
Bianca, thank you. Bianca Langon.
Right.
Bianca Langon, please. Does anybody know where Bianca Langon is?
She may have bonded. I'm sorry.
Okay.
What page are we on?
Page 5.
It's Langone.
She bonded.
She did? Okay.
Yes, she bonded. I apologize.
That's okay, no problem. All right, next one is Taryn Samad.
No problem, John.
Thank you. All right, Ms. Samad, good morning. You're charged with 1 count of possession of cocaine, $1,000 bond. Count 2, you have a capious misdemeanor for a $500 bond. That's for a trespass, a structure, or conveyance. Court does find probable cause. Anybody wish to be heard?
Yes, Your Honor. Ms. Samad has been living here for 20 years. I'm going to be asking for pretrial release, Judge.
Any objection, State?
Just need to check one thing, Your Honor. No. No objection.
Okay, pretrial release, ROR.
Okay, make sure you keep track of your court dates, Ms. Samad, so you don't miss court.
Ms. Samad, you have to report within 24 hours to the pretrial office. They close at 4 o'clock, but the latest you can get there is 3, so depending on when you get out. If not, you have to go there by tomorrow, and I suggest you go by 12 noon, okay?
Okay, Mom.
Thank you very much. Good luck to you.
Thank you.
Pardon? Only on the possession of cocaine. Thank you.
Your Honor.
Yes.
The other, the misdemeanor capious, that was just a straight ROR?
Yes.
Okay, thank you.
Thank you. All right, next one is Jordan Mack. Is that your name, ma'am?
Yes.
All right, good morning, ma'am. You have some ad charges here. Count 10, burglary of an occupied dwelling unarmed. We need to talk about bond. Count 11 is grand theft auto, $1,000 bond. Counts 12 through 17 are possess or receive or retain stolen credit debit card, $1,000 bond on each count. I'm sorry, and counts 18 through 22 are fraudulent use or possess ID of another without consent. Bond on those charges are $1,000 each. The court does find probable cause. Anybody wish to be heard with regard to bond or any other conditions?
Your Honor, she was before the court already on a previous burglary of an occupied dwelling.
Okay,
The court set a $7,500 bond on that count.
okay,
I'm requesting that the court set the same bond on this.
okay.
Judge, in speaking to Ms. Mack, she's not going to be able to bond out on the charges that she already had before this morning, let alone after this morning. I'd ask for a $2,500 bond on count 10.
Right, the court does have concern based on the nature of the allegations in this case. Court is going to set bond on count 10 at $7,500, and the court's going to leave the bonds 11 through 22 at $1,000 each count. The court is going to order no contact, direct or indirect, with the alleged victim with the initials RTF. That means no calling, texting, writing, no in person, and no third-party contact. Do you understand, ma'am?
Yes.
Right, is there any other alleged victim, State?
One moment, Your Honor. And while I'm looking, Your Honor, I imagine that also includes no return to the residence as well?
And no return. We'll go through the address. Hold on, I have 2 more people, man. There's a gentleman by the with the initials DJC. He's a junior. And SF.
And there's one more on the next page, Your Honor.
There is, okay. And with BD. And there's no return, ma'am, to any of these residences or addresses. State, would you like me to read the addresses?
Your Honor, I would ask that you not, certainly Mr. Reedy, she's represented by the public defender. Mr. Reedy has those addresses in his reports. If he doesn't, I'll provide any he needs.
Okay, and
We have them, and I think that Ms. Mack knows not to go back to those locations if she bonds out.
All right, court's also going to do a GPS level 2. Thank you. Next one, please, is Marsha Lynn Clark.
North Broward.
Marsha Lynn Clark. Good morning, ma'am. You have a charge of count 1, possession of cocaine, $1,000 bond. Count 2 is disobey or avoid a red light, which is actually a civil traffic infraction. It's not really for magistrate court. $1,000 bond. Court does find probable cause. Anybody wish to be heard?
Your Honor, I'm going to be asking for a pretrial release for Ms. Mack. She's been living at the same address with her mother for the last 5 years. Her mom, she is her mom's caregiver. Her mom has some pretty serious medical issues, and Ms. Clark takes care of her mother. I think she.
Objection state? Go ahead. While he's looking, I guess you can.
I was just going to say she has had some contact with the criminal justice system in the past. I don't think it's anything major.
Okay,
I just need to check one case,
sure.
and just so the court knows what I'm looking. She was put on pretrial in 2015 on a case. I just want to make sure that there weren't any issues with that, and I think that would give me some
It's also,
confidence.
not to minimize anything, but it's $5 worth of cocaine.
I just,
Say that?
what's that?
Did you just say that?
No, I said I
Okay.
just wanted to look up,
Ma'am, your address is 3120 Southwest 40th Ave, West Park?
Yes, ma'am.
Okay.
yeah, I have no objection to release the pretrial, Judge.
Standard pretrial release, ROR on 1. Thank you, ma'am. You have to report, ma'am, you have to report within 24 hours, okay? So if you get out today before 3, go over there. If not, report tomorrow by 12. If you don't, there'll be a warrant issued for you. Thank you.
Thank you.
Okay, we have Jamala Unique Isaac De Ramos. Hello, how are you?
Good morning, ma'am.
Is your name Jamila Isaac De Ramos?
Yes, ma'am.
All right, sir, you are charged with, ma'am, with
Yeah,
petty
ma'am.
theft, first degree, between, sorry about that, between 100 and 300,
okay.
$100 bond. Count 2 is false ID given to a law enforcement officer. That's basically an ROR. There's no bond attached to that. However, you do have 2 violations of probation. You have 2 no bond holds. Anybody know when Mr. Ramos is going before her division judge? Or it's actually this Monday, 4/23, at 8:45 a.m. Anybody wish to be heard with regard to the $100 bond?
No, Your Honor, I'd ask you just leave it in place. She can resolve that with her.
Okay, no
Division.
return to the Burlington, I believe it's the coat factory, is that it?
I believe so, yes, Judge.
Okay, no return to the Burlington coat factory, you understand?
Yes, ma'am.
All right, court is going to set your bond on count 1 at $99. You'll go before your division judge this Monday. Thank you. Good luck to you.
Thank you. Thank you.
You're welcome. Artovio Tucker, please.
Conti?
Okay. Good morning.
Good morning.
All right, Mr. Tucker, you have a capious misdemeanor. This is in front of Judge Zeller. You have no bond on count 1 and no bond on count 2. You are going before your division judge this Tuesday at 1:30 p.m. Good luck to you.
That's the whole reason we have a specialized division.
I have a question.
Sure.
I went to court the other day, and she resolved. Basically, she resolved the cases and everything. How do I resolve this fourth charge? I guess.
Well, did you discuss were these cases resolved with the judge?
Yes, ma'am.
All right. Give me a moment. Let me pull it up.
Your Honor?
Yes.
Okay.
Signed on April 17th, RORing him on this case.
So
Here, I'll,
why is he then, so then what do we do with this? Should we just delete it from the docket, or would it be easier if I just ROR'd per Judge Zeller's order? Okay,
well,
so,
They left off a charge when they booked him from the capious. And so,
okay, I
for filing
understand.
purposes, they had to go back and add it.
All right.
you might just want to advise him, there was an additional order from Judge Zeller.
she told me I was going home.
Okay, I just made notes on, in case this happens again, sir. I actually made a note on here, it'll be scanned in the clerk's screen, that Judge Zeller actually resolved this case on April 17th, 2018, which was 2 days ago. It says, and I just want to read to you what it says. It says, defendant ROR'd on this case, delete all holds. So you are going to be released today. However, it also says, after defendant is released from Broward County Jail, Mr. Tucker shall be ROR'd and make an appointment in contact with case manager. Also, attend felony drug court and complete 10 hours of community service. Miss one thing or test positive, 30 days, SAP. You understand?
Yes, ma'am.
All right,
Just to be
thank you
clear,
very much.
just so we're clear, I don't think this case was actually resolved. That's why she ROR'd him on it.
No, I understand. I'm not saying resolved. I just meant this magistrate court issue has been
Oh,
resolved.
okay. I didn't,
Thank you.
just looking to avoid any confusion.
Thank you.
You're welcome. All right, next one is Daytwan Bell, please.
North Broward.
Hello, how are you, Mr. Bell? You have criminal mischief between $200 and $1,000. First offense. Court does find probable cause. $100 bond. Anybody wish to be heard?
Yes, Judge, I'm going to ask for pretrial release from Mr. Bell. He's been a lifelong resident of South Florida. He lives with his aunt. He has had some misdemeanor priors, but I don't think he's had any felony priors. And he would be staying with his aunt if he was placed on pretrial release. And it looks like alcohol may have played a role in this incident.
Sure. Do we know your aunt's address, sir?
Yes.
What is it?
7159 Northwest 16th Avenue, Miami, Florida.
Hold on, I'm writing it down, okay?
Okay.
All right, so it is 7159 Northwest 16th Avenue.
Yes, Miami, Florida 33147.
State, any objection to pretrial release in this case?
I would be requesting pending verification, just to list that he has no address in the reports and booking.
Okay, Mr. Reedy, we can have you call.
Do you know your aunt's phone number, Daytwan?
Yes.
Let's have it.
786 343. No, wait. 786 543 1150.
What is her name?
786-543-1150.
Yes.
What's her name?
Kimona Johnson.
All right, sir, have a seat. We're going to pass your case, okay? Thank you. Christopher Hungria. Christopher Hungria.
Hungria is here present at main, Judge.
Thank you. Mr. Hungria, good morning. You have 4 KBS felonies, bond set, $250, $1,000 total. You have 3 fish and wildlife violations. And you have possessed a reptile of concern without a license. Anybody want to be heard with regard to the bond?
Judge, Mr. Hungria, he's asked me to ask the court if you would consider resolving his cases today.
No.
To know if Daytwan's released from jail, if he can come and stay with you.
Can you see if he failed to appeal?
Yeah. Looks like he had maybe have a say it's not serious, it is, but, you know, it's not really, really serious. Okay, and what's your address again?
Okay, he has a return. He failed to appear in court.
Yes. Okay.
On the KPS, the address is 8531 Southwest 5th Street, Pembroke Pines. And then I have a 620 West 189th Street, apartment 4H, New
Should be
York,
home
New York.
tonight.
Which one is it?
Okay, Kimona, thank you, good luck.
None of them are valid, Judge. I just came from New York to resolve this, that's it. I'm trying to go back to New York as soon as possible. Okay, Judge, he is residing in New York. He's advised me that he actually, I guess, flew or drove down here somewhere on the bus. He came down on bus specifically to resolve these cases.
Just wondering if he came down here from New York, why the bus didn't stop in Broward, because I noticed he was arrested in Dade County.
How long has he been at that New York address?
How long you been residing there in New York?
Well, it has his address here. And the allegations say that he was in possession of 2 Burmese pythons without a permit to possess. He did not have records of the acquisition for the snakes. They were kept in improper enclosures, and they were not locked. So this is what the court will do. His address, you said, is 620 West 189th Street, apartment 4H, New York, New York.
That's New York City. That is correct, Judge.
Okay. State, what do you want to do with this? I'm not resolving it today, I can tell you that. Would you have any objection to standard pretrial release?
Yes, pretrial, I don't see the purpose of putting someone on pretrial that lives in New York.
Well, he can call in twice a week and resolve it.
He could call in from anywhere and say he's
Okay.
in New York.
But he has to show up for court, otherwise he's gonna get arrested again. He didn't
Yeah, the
show
problem
up.
is, and he didn't last time.
Can he afford any bond?
Judge, you did give me the phone number of his mother right now. I intend on calling her after court.
All right, so why don't we recall this for the PM and we'll decide then, okay? Thank you.
You can recall Mr. Bell if you would like, Judge.
Thank you. Okay. Daytwan Bell, I believe he was in Conti.
North Broward,
Oh,
Judge.
I'm sorry.
That's all right. I did speak with Mr. Bell's aunt.
Okay.
She indicated that he is welcome to stay with her at 7159 Northwest 16th Avenue in Miami.
Okay. All right, sir. ROR, standard pretrial release.
Okay, thanks.
We don't need to verify it.
Your Honor already
pretrial.
ordered no victim contact?
Pardon?
You already ordered no victim contact, right?
No, I don't remember. Let me look. I don't have it down here, so probably not. All right, sir, we're gonna order no victim contact, direct or indirect, with the alleged victim with the initials EB. That means no calling, texting, in-person contact, or through third parties. Do you understand?
Yes.
You violate that condition, you're gonna violate the terms of your pretrial release. Thank you very much, sir.
Okay, thank you.
Thank you. Okay. Thank you, Dante. Zachary Watson, please. Good morning, Mr. Watson. You have a KPS misdemeanor for driving while license is suspended. You had a no-show March 28th, 2018, before your division judge, who is Judge Lerner Wren, Division MT. Bond set at $250. You do have court this Monday at 2 p.m.
Judge, in speaking with Mr. Watson, he wishes to try and resolve this case for time served.
Okay, did you explain to him that if he gets 3 convictions within 5 years, the Driver's License Bureau will suspend his license for 5 years as a habitual traffic offender?
I did, Judge.
All right, and he still wants to go forward?
He does.
State, any objection?
No.
Raise your right hand, sir. Do you swear and/or affirm to tell the truth?
Yes.
Okay. It's my understanding you wish to waive your right to a trial, sir?
Yes.
Anybody forcing you to do this?
No.
Are you resolving this case today because you can't afford to bond out for the $250 and you want to fight your case and you want a trial?
Yes, ma'am.
Okay, so let me ask the question a little bit better, sir. Do you want, if I ROR'd you, would you want to go to court and fight your case, or would you still want to resolve it today?
I'd rather resolve it today.
All right, I just wanted to make sure, sir. All right, so you want to give up your right to a trial. Is anybody forcing you to do this?
No, ma'am.
Under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea of his charge could result in deportation proceedings?
Yes, ma'am.
You understand also, your attorneys indicated that you understand that there's 3 convictions. If you get 3 convictions for driving while license is suspended within 5 years, the driver's license bureau will suspend your license for 5 years as a habitual traffic offender. Do you understand that?
Yes, ma'am.
And understanding that and everything else we discussed, how do you want to plead? Guilty, not guilty, or no contest to driving while license is suspended?
No contest.
Okay, the court is going to accept your plea, find that it's freely and voluntarily entered. The court is going to adjudicate you and time serve you. Court is going to impose $293 in court costs. The court will give you 90 days to pay that. If you need more than that, sir, you can go online to browardclerk.org and ask for an extension of time, or go before then and ask the clerk for a payment plan. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case, sir, except for paying the $293. Thank you. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Travis Christopher Taylor, please.
Mr. Taylor? Oh, medical reset, Judge.
Okay. Next one is J. Leonard
Spear.
Spear?
Spear.
I'm sorry,
Spear
sir.
is here, present. It's okay.
Dante, I write the medical resets on here. Ms. Jackson asked me not to write it on the top because she says you have to print another one, so I just write it on the bottom corner if you flip it. Okay, Mr. Spear, you are charged with stalking, follow, harass, cyber stalk another. Court does find probable cause. Let's talk about bond.
Honor, state is going to be requesting a $10,000 bond, no victim contact, pretrial release of the GPS monitor. Based on the allegations, the state has great concern for the alleged victim's safety and well-being.
Judge, in speaking to Mr. Spear, he's been residing in South Florida his whole entire life. He's 53 years old. At this time, he's looking for employment. What he was doing, basically, last year he was taking care of his mother, who was elderly. Unfortunately, she did pass away in 2017. So now he's trying to get back with life, and he's right now looking for employment. He lives in Miami. He's been living at the same apartment now for about 3 years. His monthly rent, from what he told me, is $638. He believes he can afford about a $3,000 bond, so that's what we're going to be requesting, Judge.
Okay, court's going to order no victim contact, direct or indirect, sir, with the alleged victim with the initials JS. That means no in-person contact, calling, texting, writing, any contact through social media, liking, disliking anything. The court also is going to do a minimum of 1,000 feet from the victim's home, work, and school. And the school is if, I don't know if the alleged victim does go to school. Court is going to set bond at $7,500, GPS level 2. Thank you. Good luck to you. Next one is James Walter Vandergrift.
Vandergrift, come on up, please.
Okay, Mr. Vandergrift, you have a capious misdemeanor for a petty theft. Does he want to resolve it, or what are we doing?
Yes, he
Bond's
does,
at,
Judge.
bond's 500, by the way.
As you can see, it's a 2-year-old case. I believe it was
Sure.
a Home Depot. I don't think there's outstanding restitution issues, so we'd be asking you to consider resolving it today, Judge.
Okay, let's, while Mr. Linder's doing that, let's just start taking the plea, and if we need to
Well, no, it's,
abort, we can.
no, this is already disposed of.
It's disposed of?
Yes, this issue is looks like he got, Your Honor, he got community service hours from Judge Miller. He didn't show up to the hearing to show his community service hours, and his capias was issued.
Okay. Set by the judge in South. Let me see the,
Well, yeah, it was reset to May 16th of last year. He didn't appear, that's when the capias was issued.
Go ahead, Mr.
From what he's advised, Judge, I believe the reason why he missed court, he said he was going through substance abuse issues. At this time, he did seek treatment, and from what he's advised me, at this time, he's 15 months clean, and he seems pretty proud of that, Judge. Having said that, Judge,
Did he do his community service hours?
No.
Okay, so then, why don't we do this? Why don't sir, is your address 6232 Funston Street, Apartment 7, Hollywood?
Yes,
All
Your
right,
Honor.
I'm gonna, ROR him. Let him, complete his community service. This will be reset. You have to check it in the computer. Sir, it would behoove you to do your community service, okay?
Thank you very much.
Thank you. Good luck to you.
good luck, sir.
Eludu Lamar, please.
Mr. Lamar, come on up, please.
How do you say your first name, sir?
Elodie?
Elodie, okay.
E-L-O-U-I-D-I-E.
Okay, thank you. Okay, sir, you are charged with DUI, alcohol, or drugs, first offense. Bond is set at $500. Court does find probable cause. Anybody wish to be heard? You're welcome.
Yes, Judge. We're going to be asking the court to consider reducing the bond to $200.
Why?
Judge, this is his first arrest.
Okay.
He's working for Sentinel Packaging. He's been there for about 17 years. Full time, he gets about $300 per week. He's a single father, raising his 2 daughters. Both of his daughters go to public school. Judge, at this time, he's been living in the same residence since 1999. Considering he does have about $200 in his property, and that basis as far as why we're going to be asking the court to consider reducing it from $500 to $200 so he can self-bond.
State?
It's fine.
No objection?
No. We just asked for an order, no alcohol or intoxicants.
No objection to that, Judge.
Okay, sir, no alcohol and no intoxicants. Of course, Mr. Romero, that doesn't include prescriptions. Okay, $250 bond. Do you need an order? I know you said before that they don't need it to self-bond, but you want one anyway?
Deputy Johnson, he needs to get, access to his property bond. He just has to tell deputy, right? No, okay. No, it's not necessary, Jeff.
All right, fine.
Thank you, though.
You're welcome. Jimmy Jean Charles, please.
Conte.
Yesterday that I was holding on to.
Okay, are you Mr. Jimmy Jean
Sexual
Charles, sir?
predator on top of it.
Yes, ma'am.
All right, sir, you have 2 ad charges for capious felonies, bond set at $750 and $100 for a total of $850. This is a refile of case number 17-1608. It has MM10A, so now I guess it's a felony, correct, State? It is. You're going to be going before Judge Elizabeth Shear this Monday at 8:45 a.m. What does he have for counts 1 through 10? Did he bond out or?
Count 10 is a no bond, as Mr. Gene Charles and I discussed earlier. It's a no bond for a felony DUI, so Mr. Gene Charles is going to have to go in front of Judge Shearer.
All right, so bond on count 11 is $749. Count 12 is $99. Thank you.
Excuse me, Judge.
Yes.
I want to ask you, ma'am, for what year was this charge? 'Cause
It was 2017, it appears. It's a refile from a misdemeanor case.
okay.
All right?
Okay.
All right.
All right.
Thank you. Good
Thanks.
luck to you, sir.
Thanks so much.
You're welcome. Terrence Dean Williams, please.
Conti.
How many more you have at Conti, Deputy?
Sorry, ma'am.
How many more you have there?
4.
Okay. All right, then we'll just continue on the regular docket. Okay. Terrence Williams, you have a charge of, it's an ad charge of count 2, grand theft, $5,000 bond. You are going before your division judge, who is Judge Paul Backman, this Monday, April 23rd at 8 a.m. Anybody wish to be heard with regard to the $5,000 bond?
Well, it's a capious judge, no. He has a
Okay.
$1,500 bond on count 1, and it looks like counts 2 and 3, he does
Well,
not
this
need
is
to
an
post a
ad
bond.
charge, so,
Right.
okay. $4,999. Thank you. Okay, Joseph Rita.
Conti.
Thank you. Okay, Mr. Is it Retta or Rita?
Rita. It's
Rita,
R-E.
okay. All right, thank you. Sir, you have a count of, you actually have ad charges 17, 18, 19 of grand theft on each count between $300 and $5,000. $1,000 bond on each one. Anybody wish to be heard?
Judge, I think that counts, I just want to double check, but I believe that all of the other counts have been resolved with community control. These are the only charges that he actually has pending. He's already on community control, being supervised.
So what are you asking for?
I'd ask you to, Mr. Rita, how much bond can you afford?
I can't afford nothing right now. I was on they gave me the GPS so I could go back and work. 'Cause I work for a month.
I have no objection to release the pretrial, Your Honor.
Yeah, I'd ask that, Judge. He's already being supervised, so what's 3 more charges to supervise him on?
Okay, pretrial what? GPS?
He's got a
No,
GPS.
I'm fine with our just standard pretrial on these 3.
Okay, sir, so on count 17, 18, 19, court's going to ROR you. However, you're going to be on standard pretrial release. You are not to return to the Coles at 6950 State Road 7, Coconut Creek, Florida, 33073. Okay, sir?
Okay, Miss Teresa.
Okay. All right, so let me ask you a question, sir. Is your address 601 Northwest 21st Court, Pompano Beach?
Yes, it is, ma'am.
All right, if your address changes, it's your responsibility to notify the clerk of the court because you do have these 3 pending cases, okay?
Yes, I will, ma'am.
Thank you. Good luck to you.
Thank you, too.
D. Cedric Sconiers.
All Ryan, Judge, we waive formal reading of the charge.
All right. Mr. Dedrick Sconiers, sir?
Good morning.
Good morning. You have an ad charge here and no bond hold. You are going before your division judge. Thank you. Judge Barbara McCarthy on April 23rd, which is this Monday, at 8:30 a.m. We need to talk about bond. Court does find probable cause. The court is going to order no victim contact, sir, direct or indirect, with the alleged victim with the initials SG. No contact, direct or indirect, sir, means you're not to call this person, you're not to be in person with this person, no physical contact, and no texting, calling, writing, anything on social media, even liking, disliking anything, and certainly no contact through third parties. Do you understand, sir?
Yes, ma'am.
All right. State.
Your Honor, on count one, which count one involves one of the alleged acts, the ad charge involves the other. He was given a $100,000 bond, pretrial release, GPS level 1 monitor, no victim contact. On this count, I'm going to be requesting a $50,000 bond with the same pretrial supervision level 1 GPS and no victim contact.
Defense.
Judge, he's never going to be able to make that $100,000 bond, so I think what he needs to do is go in front of Judge McCarthy on a motion to reduce bond.
All right, so this is what the court's going to do, sir. Court is going to, you have to go before your division judge. Court is going to put you on GPS level 1. You are going before your judge on Monday, sir. Court is going to set bond at $100,000. You'll be able to, your attorney in that division will be able to file a motion, okay? Thank you. Leary Kemp, please. Lee Ray Kemp, I'm sorry. All right, Mr. Kemp, good morning, sir. You have a charge of ad charges, count 7, false owner info for pawn items less than $300, $1,000 bond. And count 8, sir, is dealing in stolen property, $3,500 bond. Court does find probable cause. Court's going to order no victim contact, sir. Did you hear me tell the other gentleman what that means?
Yes, ma'am.
All right, and that's no contact. Hold on, direct or indirect, with the alleged victim with the initials TAF. Anybody wish to be heard with regard to the $1,000 and $3,500 bond?
Mr. Kemp has a no bond violation of probation hold right now, Judge. It's count 3.
Okay.
I think we were wondering when his next court date would be.
Yeah, I don't have one on here, I'm sorry.
I don't have one either.
Sir, don't talk about the facts of your case, okay?
Yes, ma'am. I just want to ask, so is my the charge, what is that?
Do you want to know what this charge stems from? Is that what you're asking?
Yes, ma'am.
All right, it says on 1/17/18, and I'm just paraphrasing, you entered into the Value Pawn Shop located at 3181 North Dixie Highway in Pompano and pawned the victim's Jimmy Choo sunglasses, saying you received $50. Don't comment to it, but they said the glasses were worth around $400. So the rest, you can speak to Mr. Reedy. He can call you in a moment unless you have another question, sir.
Yes, when I'm reading my charge, it's saying less than $300, and so I thought that would be a misdemeanor.
Okay, it says the glasses are valued at $400. Speak to your public defender about it. I really don't want to get into talking about the facts of your case.
I understand. Thank you.
Your Honor, I can advise the court, Mr. Kemp, his first VOP hearing originally was March 26th. Okay. He denied the allegations. His next status hearing is before Judge Scheer on May 9th.
Okay, so you're going before your division judge on May 9th. So what are we doing with the bond on count 7 and 8?
I just ask you to leave it where it is, Judge. He's got a no bond hold.
All right, $999 on 1, $34.99 on 2. No victim contact, sir. Thank you. Next one is Fabian O'Neill Moncrief. Okay, Mr. Moncrief, you have ad charges. Count 27 is robbery, no firearm or weapon. Count 28 is battery on a person 65 years of age or older. And count 29, burglary of an occupied dwelling unarmed. We need to talk about bond in all those cases. And count 30 is grand theft between $300 and $5,000. Anybody object to probable cause?
I believe count 1 looks like an attempted robbery to me, Judge.
Which, it's actually my 27.
Yes, count 27.
Is that the only one that you're objecting to?
Yes, Judge.
Okay.
Mr. Moncrief has significant bonds on his other charges.
Okay.
I don't believe, based on my conversation with him, that he's going to be able to bond out as things stand. He's probably going to have to go in front of his division judge on a motion to reduce bond.
Your Honor,
Right.
this,
Sir, the court is going to order no victim contact, direct or indirect, with the alleged victims in the case, with the initials RN, JH, and DH. Did you hear me before state what direct and indirect, sir, means? Means no contact in person, calling, texting, writing, social media, or any contact through third parties. Do you understand?
Yes, Your Honor.
Thank you. All right. State, go ahead. I'm sorry.
Your Honor, that's okay. The state is okay with the attempt for the PC.
Okay, so PC for attempt only on count 27. Okay, so state, what are you asking for bond, 27, 28, 29, and 30, please?
The state would be asking for a $10,000 bond on each count,
We're on 27 through 29. We're
on
fine.
27 through 29. Counts
Okay.
27.
You wish to be heard further, Mr. Reedy?
Well, as I said, Judge, Mr. Moncrief isn't going to be able to bond out as things stand. I think those bonds are excessive. I'd ask for a $2,500 bond on each count.
Okay, court is going to set bond on counts 27, 28, and 29 each, $9,999, and on count 30, $999. Thank you very much. Good luck to you, sir.
Your Honor,
Yes.
I feel we have one more person.
Who is that?
Right there.
Bruce
On the right.
Hodgson.
Who?
Bruce Hodgson, he's on page 27. He got moved.
Okay, bring him in. He is? Okay, are you Bruce Hodgson, sir?
Yes, ma'am.
All right, good afternoon or good morning, sir. You have count 1, burglary of an unoccupied structure, unarmed. We need to talk about bond. And count 2 is a capious felony, sir, for a $50 bond. I'm sorry, $500. These are actually a capious, add count 2, and change a charge to count 1. So it's burglary of a structure unoccupied. We have to talk about bond and criminal mischief, damage greater than $1,000, $500 bond. Any objection to probable cause?
No, Judge. I had Mr. Hodgson listed as main jail, so I didn't speak with him.
Okay.
I do know that the capious is a criminal mischief.
Yes.
It's an ad charge. Mr. Hodgson, how much bond can you afford?
Add charge to count 2 and change a charge count 1, so.
The first charge was, I've been in here for 40 days, and the first charge was, now they say there's no charge on my paperwork, the burglary one.
Well, the question was, how much bond can you afford?
I'm not sure right now.
Is there somebody I can call to bond you out?
I gotta talk to my father if I can see if I can do that, I don't know.
I'll call your dad for you.
Alright,
He actually had a hearing. He has a hearing tomorrow before your division judge, who is Judge Tim Bailey, tomorrow at 8:30 a.m., sir.
And, Your Honor, there really hasn't been I provided the court with a copy of your original findings. There has not been a change of charge from the PC finding you originally made. He was charged incorrectly for armed burglary. Your Honor found probable cause. As you can see, you crossed out the armed. You found probable cause for burglary of a structure, which is what he was charged with. And you said, I believe,
So this is just a technicality.
It's a technicality, Your Honor, and that's why we're going to be.
Yeah, because they had him on the paperwork, Mr. Reedy, as burglary of a structure or conveyance armed, and I crossed it out and it says burglary of a structure. So based on that, Court's gonna keep the bond on count one at $5,000. The capious felony is $500. So I'll tell you what, I'll make that $499. You're gonna see your judge tomorrow, sir. Good luck to you, okay? 8:30 in the morning. Speak to him about the bond or your public defender.
Alright.
Thank you. All right, we're gonna take a break. We'll be back in 15 minutes. to you soon. Okay. All right, welcome back, everybody. Stefan Baron, huh?
Hi, Your Honor. How do you pronounce your last name, sir? Barrigo?
Sorry, sir. Okay, sir, you have one count of assault, no bond attached to that, which is basically an ROR. Count 2 is possession of buprenorphine, $1,000 bond. Any objection to probable cause?
With a
Prescription. State?
He declined the services of public defense.
Okay, listen, I didn't decline that, but I have a prescription for that. So what can be done?
Okay, sir, so let me ask you this. State, what's, just hold on one moment, sir.
Okay. Because I've been like wrongfully charged in a way.
Hold on, sir. Don't talk about the facts of your case. Let's just talk about bond and your release, okay?
Okay, thank you, but it's okay. Anyways.
Okay.
My mom's a paralegal, and I had my share of Broward County.
All right, well, hold on. Just give us one moment. Okay, the court does find probable cause. State, what would you like to do with, can you afford a $1,000 bond, sir?
I can. Well, can you do RR instead?
You can afford it?
But I've been charged wrongfully, so I'd rather you do RR because I have a prescription for that. The girl came to my house and hit me, lied on me, and it's a bunch of...
Okay, sir, hold on. Don't talk about the facts of the case. You'll have your day in court. I know it's hard not to talk.
Okay. So there's no RR completely, please?
State, does he have any priors?
Your Honor, he has a 2016 domestic violence battery. It was null pros. And
All right, sir, just hold on.
a 2013 deliver oxycodone, second degree felony, adjudicated possession of hydrocodone, 2012, 2010 deliver cocaine, adjudication withheld, 2010 operating without a valid license, adjudicated guilty, 2010 adjudicated withheld possession of cocaine with the intent to deliver, possession of oxycodone, possession of oxandrolone, possession of cannabis with the intent to sell, possession of drug paraphernalia, battery, possession of displaying a license, invalid license, 2011, 2009 DUI. And Your Honor, on count 1, even though it's an assault, he is charged incorrectly. It looks like it should be a battery, so the state would be okay with the $1,000 bond on count 2. If it was charged correctly, it would be a battery, or a $1,000 bond on that count.
She lied on me, and that's a
Sir, just give me one moment, okay?
Thank you, Your Honor. They owe me restitution. This time.
Well, he's...
I know.
All right, so the court does find probable cause. Sir, I'll give you the option. You can either, well, first of all, you have no victim contact, direct or indirect, with the alleged victim with the initials AA. That means no calling, texting in person, anything on social media, and no contact through third parties, and no emailing or anything like that. No contact means no contact. As far as the $1,000 bond, I'll give you this option. You can either go on LRORU, put you on pretrial release. You have to report in person once a month, call in twice a week, and report 24 hours. So $1,000 bond or pretrial release, which one is it?
$1,000 bond.
Okay, $1,000 bond it is. Good luck to you.
Thank you, Your Honor.
You're welcome. David Garman, please. Mr. Garman, come on up.
Mr. Garman refused to join us today, Judge.
Okay, so Mr. Garland voluntarily absented himself from the court. Any objection of probable cause?
No, ma'am.
Bond set at $1,000. Anybody want to be heard?
No. Looks like he's got a Dade County hold.
He does?
Yeah, he just brought here from
Dade County holds. Okay, based on that, court will set bond at $999. All right. Next one is Revon Riles, and after that is Dwayne Atkins.
Mr. Riles is represented by Bill Jellin. He said he would be here shortly.
Okay.
Mr. Jones coming, sir.
All right, Dwayne Atkins, please. And after Mr. Atkins is William Flynor. Are you Mr. Dwayne Atkins, sir?
Yes, ma'am.
All right, sir, you have count one, grand theft auto, $1,000 bond. Count two, you have a no bond hold, which actually is not for magistrate court. I'll tell you what that is.
No, I was just
Says
looking
no
for
show
someone.
at change of plea. That is before, who is MD? No, can't be Mindy Solomon. Oh, Judge Barbara McCarthy. You have a no bond hold. Any objection, probable cause?
No, Your Honor.
Court does find probable cause, sir. Court's going to order no victim contact, direct or indirect, with the alleged victim, R.P. Jr. Did you hear, sir, what I said, what no victim contact, direct or indirect means to other persons that came before you, sir?
Yes.
Okay, so no victim contact. Anything else? Anybody want to be heard with regard to the $1,000 bond since he has a no bond hold?
Judge, at this time, considering he has no bond hold, will be waiving, would be deferring our argument for the future.
Okay, $9.99. Next one is William Flynor, please.
North Broward.
And then we have Chaka Smith.
No, sorry, Your Honor.
All right, thank you very much.
He's approaching right now.
All right. Hello, Mr. Are you William Flynor, sir?
Yes, ma'am.
All right, sir, you have count one, possession of cocaine, $1,000 bond. You do have two violations of community control in front of Judge Michael Rothschild. You're going to be held no bond on those charges. You are going before Judge Rothschild on Monday at 8:30 a.m. Court does find probable cause. Anybody wish to be heard with regard to the $1,000 bond?
No, Your Honor. Mr. Flynor will have to go in front of Judge Rothschild.
Okay, $999 bond, sir. Thank you very much. Good luck to you. You'll see Judge Rothschild Monday. Chaka Smith, please, and then we have Christopher Nelson. Chaka Smith, please. Hello, sir. Hello. You have one count of carrying concealed firearm, sir, $1,000 bond. Count two is a capious misdemeanor for no lodging on city-owned property. Court does find probable cause. He did have a no-show at arraignment. That's what that $100 for the no lodging on city property is. Anybody wish to be heard?
I have proof that I was there in court.
Judge, and speaking, Mr. Smith, in reference to count one, the $1,000 bond, he's not going to be able to afford that. We're going to be asking you to consider releasing Mr. Smith on pretrial release. He's 36 years old. He's been here residing in our community for over 30 years. He is working. It's kind of like a day labor place in construction. He gets paid about $50 per day. He did find a place now to live. He's living in Hollywood. Just started residing there in an apartment. His monthly rent is about My understanding is he has no prior serious charges as far as felony goes. He's a veteran. He served in the United States Army National Guard from 1999 through 2003 when he was honorably discharged. Judge, at this time, I'd ask you to consider releasing Mr. Smith on standard pretrial release. He will be coming to court, and he's not a flight risk, Judge. And Judge, from what he's advising me, as far as count to the municipal ordinance, from what he's advised me, he actually went to court. When he went there was nobody there, so I don't know the facts and circumstances of that. From what he's saying, he didn't willfully try and miscourt. Actually, he was there. But
I do have the paperwork that the county clerk gave me. I did make sure they signed the paper, the actual paper to show I was there.
I have to tell you, Mr. Romero, the court has a concern here. He had 2 guns that were allegedly found in his waistband. He was riding his bicycle and he was aggressive towards a female and her dog, and he lifted up his shirt to show her his possible firearm. And then he told the officer, "Don't take another step towards me." So the court does have a concern for the safety of the community.
I understand, Judge. I know Mr. Smith is being he's denying those allegations. He is looking forward to his day in court.
I understand.
Like I said, he has minimal contact, so it will be hashed out in the future. He is presumed innocent, so I'd be asking for pretrial release.
State.
Your Honor, the judge would be asked. The state would be asking for a $1,000 bond based on the facts. And the state would also be requesting that he not have any firearms or ammo or weapons.
All right, this is what the court's going to do. The court's going to leave the KPS the $100 in place on count 1. The court is going to raise the bond to $2,500. As I stated earlier, the court has a concern with the allegations in the case and based on the totality of the circumstances. Sir, no firearms or ammunition. If you do possess any when you're released, you are to surrender them immediately to your local police department. In addition, the court is going to put him on standard pretrial release, which means when you're released, sir, you have to report within 24 hours. I'll give you a map. Thank you and good luck to you. Christopher Calvinel Nelson, please. Calvinelli Nelson. Sorry, sir. Did I say that right? Calvinelli?
2 pending cases.
Okay. All right, sir. You have.
Services of public defender, Judge.
Okay. All right, Mr. Nelson, you have count 1, burglary of an unoccupied structure unarmed, no bond attached to that. Count 2 is a grand theft between $300 and $5,000, $1,000 bond. Count 3 is criminal mischief between $200 and $1,000 first offense, $100 bond. You do have a no bond hold, sir, on count 4, which is your probation violation. Don't talk about the facts of your case. So the violation of probation, do we know when he's going before his felony judge? Huh?
It's an interstate.
Hold on, sir.
It's an interstate.
Oh, it's an interstate probation violation. All right, court does find probable cause. Anybody want to be heard with regard to count 1, state?
Mr. Nelson is currently being supervised by pretrial service in case 13-12291 CF10A and 17-8099 CF10A. The 13th case is delivery of cocaine. 17th case is 1 count of burglary conveyance.
Those
1
are
count
pending?
of grand theft in the 3rd degree.
Those are pending?
Yes, ma'am, they are. He's currently on pretrial supervision for both cases.
All right.
Based on this court's finding of probable cause, we're going to ask that his pretrial status be revoked at this time.
Okay. State?
Your Honor, he is being currently charged with the same charge that he's being charged with today, a burglary conveyance. The state would be asking for a $7,500 bond at this time.
What's his priors? Where's
Do you
this
say
VOP
those even though
at?
they're dismissed?
Does anybody know?
Judge, quickly, I know Mr. Nelson's asking me, he's saying that he's not on probation. I don't know if the court could go ahead
So-
and clarify that.
That's what I
which
asked them,
ones?
which
Just
state
those
it's
four right
from.
there?
They're looking it up, because I don't see that in here. It's a 948.
It's not interstate. They just didn't put the case number, booking didn't put it correctly. It's 13-12291, CF10A. He actually has a pending,
So they violated his pretrial, you're saying?
no. He was on probation.
Yeah.
And I imagine while he was on probation, Judge Porth also wanted him supervised by pretrial. So it's actually a violation of both.
So is it I don't understand, is it a violation of community control, so to speak?
No, it's a violation. He was on probation on
Yeah.
13-12291 CF10A.
Okay.
At some point in time, he was placed also on pretrial. He was being supervised by probation and pretrial. So a new arrest would violate both.
He had a curfew 7 to 6, may travel, I don't know what it says about a county, and all other conditions remain.
And I imagine that's why.
So he modified his pretrial on March 16th.
Yes. And that's why he.
Pretrial one? Go ahead.
He has a 94806 hold for violating the probation, but pretrial is also seeking to revoke because he had conditions with their supervision as well.
Okay, go ahead, defense.
What is it?
Judge, Mr. Nelson is, I believe, a little bit confused. He keeps on telling me that he's not on probation. I'm trying to explain to him that he was on probation in Broward County. My understanding of hearing Mr. Lender, I believe he went in front of his judge, and the judge released him on pretrial release. So even though he's on pretrial release, he's still on probation. That's the point I was trying to explain to Mr. Nelson. Having said that, Judge, Mr. Nelson advised me to let the court know that he really can't afford anything as far as bond. He's on disability. He gets about $700 per month. He's been living here his whole life. He lives with his girlfriend and his children. She's not in a position to post his bond. I do understand that he's being held no bond on count 4. He's just asking that you take that into consideration in determining a reasonable bond on the cases that are here before you.
All right, Ms. Patrice, what you handed me does say interstate.
The one, that was me.
Oh, sorry.
That's okay. The one, I think it's either at the very top or the very bottom. Just says Broward.
Yeah, it does, but he does have interstates, so he is on probation out of state.
Well, I think those have
But it's
already
here?
ended. I think those have ended, and then it's just the one that's out of Broward.
Okay. All right.
Your Honor had asked about priors. In 2011, he had 2 counts of burglary of a conveyance, theft, and resisting without violence dismissed on competency grounds. A 2011 battery on a law enforcement officer resisting with violence and without violence dismissed on competency grounds. 2010, delivery of cocaine dismissed on competency grounds. In 2011, burglary of a dwelling with a battery dismissed on competency grounds. There was also a violation of pretrial release conditions. I imagine that was a no contact order dismissed on competency grounds. Lots of other cases that were dismissed on competency grounds before that. Strong arm robbery, battery on a law enforcement officer, possession of cocaine with intent to sell or distribute within 1,000 feet of a school.
Okay, sir, you're to have no victim contact, direct or indirect, with the alleged victim with the initials LMR. Is that the only one state?
One moment, Judge.
Direct or indirect, sir?
That's it. Yes, Your Honor, that's all.
Direct or indirect, no contact, sir, means no in-person contact, calling, texting, social media, or anything like that. Court is gonna, you do have a no bond hold on count 4. Court is gonna revoke your pretrial and order that you be held no bond in those cases. Count 1 is $4,999, count 2 is $99,999, and count 3 is $99. Thank you, sir, and good luck to you. and that's the revocation of the pretrial is in 13-12291 CF10A and 17-8099 CF10A. Next one is Christopher Michael Dreher. Come on up, sir. You have a possession of cocaine, $1,000 bond. Count 2 is not for magistrate court. It's actually a civil traffic infraction, which is a disobey, stop, or yield sign. The court does find probable cause. Anybody want to be heard with regard to the $1,000 bond?
Yes, Judge. We're going to be asking you to consider releasing Mr. Dreher on standard pre-trial.
Okay, you have any objections, State? Let me confirm his address. Is it 959 Southeast 2nd Ave, apartment 35, Deerfield?
Yes, it is, Your Honor.
Okay, any objection, State, to
Your-
standard pretrial?
Your Honor, the state would be fine with that.
Okay, standard pretrial release, ROR on count 1. Sir, you have to report within 24 hours.
There's the location of pre-trial. If you don't report, it's going to be a warrant issue for your arrest. As soon as you get released.
Okay, Delton Eric Tompkins, please, and then we have Gregory Roundtree.
Mr. Tompkins is in North Broward, Judge.
Sure. Okay, Mr. Tompkins, please. Delton Eric Tompkins.
Your Honor, he's a medical reset.
Oh, I was just talking to him this morning. Is he okay?
I know. He went back to the unit.
Okay.
All right, if you
All
ever
right.
need us to take someone out of turn because they just can't sit there anymore for medical reasons, just let Mr. Reedy know and we'll try to speed it up, okay?
Yes, ma'am.
Thank you.
1 o'clock.
Gregory Samuel Roundtree?
Yep. Okay.
Gregory Samuel Roundtree, please.
It's Mr. Tompkins, co-defendant, Judge.
Okay, Mr. Roundtree. Good morning, sir. You have count 1, possession, receive, retain, stolen credit card, $1,000 bond, same for counts 2 and 3. Count 4 is sell, manufacture, or deliver forged, stolen driver's license or ID, $1,000 bond, sir. Count 5 is resisting an officer or obstructing without violence, $100 bond. And count 6 is trespassing, unoccupied structure or conveyance, $25 bond.
Do I say that
Court
he's been in
does find
prison or
probable
which
cause
case?
unless I hear an objection. Anybody wish to be heard with regard to the $4,125 in bond?
Judge, we do. Speaking of Mr. Roundtree, we're going to be asking you to consider releasing him on pre-trial release.
Okay.
I'll let the state see if they have an objection.
Because he hasn't opened.
Okay, there's gonna be no victim contact, sir, direct or indirect, with the alleged victim with the initials RC. Do you understand?
Yes, ma'am.
And you heard me explain to someone before what direct or indirect contact means? All right, very good. State?
The state would be asking for a $2,500 bond on counts 1, 2, and 3. He has a open, which one? Fleeing and eluding, felony criminal mischief, or resisting without violence, and a 2013 delivery of cocaine. He served 67 months in state prison, and a 2012 burglary dwelling. He violated probation on that and had served 6 years. There's a burglary of a structure unoccupied, grand theft, $10,000 to $20,000, violation of probation. He served 5 years. A possession of burglary tools. He violated probation, served 5 years. An attempted burglary of a dwelling and a resisting without violence. He served 5 years. Burglary of a structure unoccupied, a grand theft between $300 and $5,000, violation of probation, 5 years. Criminal mischief, violation of probation, 5 years. Grand theft auto, resisting without violence. He served 5 years, and a robbery with a firearm, deadly weapon. He served 6 years, as well as an aggravated battery.
Okay, Mr. Romero, go ahead.
Judge, Mr. Roundtree is 26 years old. At this time, he's unemployed. He's looking for work. He lives in Pompano Beach with his aunt. His aunt, what she does is basically takes care of kids for a living, babysitting, in other words. Right now, from what he advised me, no one's in a financial position to post his bond, so he can't afford the bond that's right now currently set, let alone what the state is asking for as far as $2,500 on each count. So, Judge, we still be asking you to consider releasing Mr. Roundtree on standard pretrial release.
What's his address at his aunt's?
You don't have it memorized? That's right, I'm calling this right now. Judge, he doesn't have that address memorized. He just moved there.
Okay, can
She
he
just
afford
moved
any
in.
bond, or is he at large, basically, besides the aunt?
That's where he's living. He just moved in.
Okay, court's gonna keep the bond at 1,000 on count 1 and 2. Count 3, the court will ROR. Count 4, the court will ROR. Count 5, the court will ROR. Count 6, the court will ROR. However, the court will do a GPS level 2. Or you know what? Tell you what, Mr. Romero. I'll ROR him on all 3 counts, GPS level 2. He's got to update his address, okay?
Yes, Judge.
Thank you.
Over the state's objection, Your Honor.
I understand. Danio de Oliveri Pereira.
Your Honor, the Portuguese interpreter should be here this afternoon around 1:30.
All right, so we'll reset for PM, Portuguese. Interpreter?
It's like,
Thank you, Mr. Romero, Mr. Reedy.
You're welcome, Judge.
Okay, Gerby, Babetto, Joseph, please. And then we have Travis Davis after that. Okay, are you Mr. Joseph, sir?
Yeah.
All right, sir, you have a capious misdemeanor, no bond holds.
What's it, just trying to post it 20
For possession of cannabis over 20 grams, that is Division MH, which is Christopher Pohl, Judge Pohl.
no, Judge, MA is Brown.
Okay, sir, I'm talking. Please listen to me. Okay, you have a capious misdemeanor, no bond hold, in front of Judge Pohl. You are going before your division judge April 24th at 9 a.m. Count 2 is a hold for the U.S. Marshal's Office. That's no bond as well. That's actually not for magistrate court. So you're going to be held no bond on both those charges. Thank you. Travis Davis, please. And then after Mr. Davis is Mr. Saunders. Good afternoon, sir. You have a trespassing, unoccupied structure or conveyance. Bond is set at $25. You also have count 2, a probation violation or community control. You are being held no bond. You are going before your division judge this Monday. It's Judge Tim Bailey at 9 a.m. Anybody wish to be heard with regard to probable cause or of a $25 bond?
Not at this time, Judge.
All right, court's going to set the bond at $19. On count 1, you'll see your division judge next week, sir. Good luck to you. Gregory Rashad Saunders, please. Good afternoon, sir. You have count 1, grand theft auto, $1,000 bond. Counts 2 and 3 are essentially RORs. That's operate a motor vehicle with a license expired. Count 3 is driving while license is suspended. Second offense, that's also a no bond attached to that. Counts 4 and 5 are capious misdemeanors. Bonds are set at $500 per count. You do have count 6 and 7, which are capious felonies, no bond hold, which actually are not for magistrate. And count 8 is a capious traffic, another $500 bond. Court does find probable cause. In your 1 misdemeanor case, you are going before Division MH, who is Judge Christopher Pohl, this Tuesday at 9 a.m., and the other one in Division M. I can't read that. Can someone tell me which division? Is that MS? Let me look at the capious. You can set it, Michelle. No, it's MH. MH and MD. Oh, Judge Solomon. He has no bond holds for no show at arraignment in front of Judge Martin Fine. Anybody want to be heard with regard to the bonds?
Judge, Mr. Saunders insisting on me asking the court, would you consider lowering the bond because he's homeless, he can't afford it?
All right. One moment, sir. I'll answer your question in a moment. I do see a count 9. Court does find probable cause as well. There's no bond attached to that. It says license not carried or exhibited. So, sir, I will tell you, you are going before your division judge, Judge Pohl, this coming Tuesday. Considering you have no bond hold, I won't do anything with the bonds at this point. I will set bond on count 1 for the Grand Theft Auto, $999, and the 2 capious misdemeanors, $499, $499 on 4 and 5, and on count 8 as $499. I'll put it without prejudice. You can address those before Judge Cole on Tuesday. And the no bond hold, does anybody know when he's going before his division judge? The felony one? Anybody tell me? He what? Okay, you don't have a date yet in front of Judge Fine, so contact your public defender, sir, and ask him if he can set a court date in front of Judge Fine on your no bond holds, because that's really what's going to be holding you, okay? Good luck to you, sir. Dion Jackson, and then we have Tom Joseph, please.
Mr. Jackson's approaching, Judge.
Okay, good morning, Mr. Jackson. You have sell cocaine within 1,000 feet of a place of worship, convenience business. $7,500 bond. Count 2 is possession of cocaine, $1,000 bond. Count 3 is tamper with or fabricate physical evidence, $1,000 bond. Any objection to probable cause?
Yes, Your Honor. As to count 1, they did not test the cocaine that was found on the individual that Mr. Jackson is accused of having sold cocaine to. The report indicates that the officer had a clear view of Mr. Dreyer handing cash to Mr. Jackson and Mr. Jackson handing him something, an item. We don't know what that item is. Okay. They stopped Mr. Dreyer. Subsequent investigation revealed that the person had purchased $20 worth of cocaine, but they didn't test that cocaine. So we don't know what it is that Mr. Jackson handed to Mr. Dreyer. And without that knowledge, without that element of the crime being present, there is no probable cause to believe that Mr. Jackson was selling cocaine within 1,000 feet of a place of worship. We do not argue probable cause with counts 2 or 3.
Okay, State. Sure. Okay, let's be heard on bond, Mr. Romero, while we're discussing PC.
To 183218, CF10A, sale of cocaine.
The court finds probable cause for 3?
Let's talk about 1. Do you have any objection, or you want to?
No, Your Honor, we're going to ask
They have no objection to 2 and 3. That's what Mr. Reedy just said.
Okay.
So let's talk about probable cause on 1.
Oh, we're going to ask for 24 hours on count 1.
Okay, 24 hours to perfect on count 1, so the court will leave the bond at, is it 75? It's so hard to read.
7,500.
7,500, okay. And counts 2 and 3, wish to be heard? Or bond on 1 for that matter.
It doesn't look like they tested anything in this case, Judge.
I'm fine with 24 hours on count 2.
Okay, 24 hours to perfect. So does anybody have any objection to me finding probable cause on count 3?
Well, I think no matter what it was that Mr. Jackson is accused of trying to stomp on, whether it's cocaine or not, it's still potentially evidence in a case. So I would not make an argument on count 3.
All right, so I'm going to put probable cause on count 3, which is $1,000 bond. Put no testing of cocaine, 24 hours. All right, so anybody wish to be heard with regard to bond, and then we'll address his pending case.
Judge, from what Mr. Jackson tells me, he's 23 years old. He just got a job. He just got hired at Five Guys, making minimum wage. He's living in Deerfield with his sister. His sister is a security guard, so that's the person he's going to be contacting. I'll post his bond. Right now, from what he informs me, the current bonds, which are currently set at $9,500 total on counts 1, 2, and 3, is something that she's not going to be able to afford. So we'd ask you to take financial resources into account in determining a reasonable bond on behalf of Mr. Jackson.
I see what it says. He's on an ankle monitor?
No, that's,
Oh,
pretrial's gonna bring that to the court's attention.
I see that, the police officer.
What I'd like
Go
the
ahead.
court to be aware of, that arrest for selling cocaine took place at 313 Southwest First Terrace. This allegedly occurred at 300 Southwest First Terrace.
You mean in the 183218?
I'm
Is
sorry?
that what you're comparing it to, the other, I don't know what you're comparing it to.
It's the same location.
Okay,
On 2 separate dates, he's at the same location allegedly selling drugs.
so you're referring to 183218 CF10A, the address
Yes,
on that?
yes, I didn't know, yes, I am, Your Honor.
All right, go ahead.
And I understand Mr. Romero's advising the court that he just started a job, but clearly it would appear that Mr. Jackson is also engaged in selling narcotics. His criminal history, in addition to that, 2017, robbery by sudden snatching, false imprisonment, felony battery due to priors, theft, sentenced to 364 days in county jail and qualified as a habitual offender. Possession of cocaine, 2016, violation of probation. Battery, 2014, violation of probation. 2014, delivery of cocaine, violation of probation. 2013, felony possession of a controlled substance.
Okay, Ms. Patrice?
Yes, ma'am.
Okay.
What are you requesting for 183218 CF10A?
Based on this court's finding of probable cause on count 3 that his pretrial status be revoked.
Okay, that's granted. I'm gonna revoke. And no bond. Anybody want to be heard with regard to the 7,500, 1,000, or 1,000 further?
Well, now that he's being held no bond, Judge, why don't we wait until tomorrow and see if the state's able to perfect counts 1 and 2 and
Okay.
talk about it then?
Okay, no problem. Thank you.
What's the case number that you wrote, Judge?
It's 18003218 CF10A.
Thank you.
Thank you. Tom Joseph, please. And then Michael Polanco Munez.
Yeah.
But I can't find him.
Okay, Mr. Joseph, good afternoon. You have a possession of cocaine, $1,000 bond. Court does find probable cause. Bond set at $1,000. Anybody wish to be heard? Thanks.
Judge, yes. We're going to be asking you to consider lowering the bond from $1,000 to $100 for releasing Mr. Joseph on standard pretrial release.
I'm sorry, you said lower it to what?
To $100
Okay.
or releasing him on standard pretrial release. And I'll wait to see if the state has any objection before I proceed.
One moment, Your Honor.
Thank you, Mr. Romero.
Does pretrial have any notes if he's had prior failures to appear?
Says he has an address. One says at large, and then the other one says 370 Southwest 27 Terrace, Fort Lauderdale. Is that where he gets his mail or lives?
That's where he gets his mail.
Okay.
That's where he gets his mail.
All right.
I don't see any other.
Yeah, Your Honor, we'd be opposing a $100 bond, but pretrial would be fine.
Standard pretrial release, sir?
Your Honor, we are asking for random drug screening, drug testing.
Okay, random testing. No alcohol or intoxicants, only prescriptions.
Yes, Your Honor. Let me give you a
Sir, you to report within 24 hours.
Be careful. If you don't show up, there's a warrant issued for your arrest.
All right, and then we have, who do you have that's left there, Mr. Romero?
The next person would be
Michael?
Jacoby Jackson.
Okay.
Come on up.
And then you have Bronzavia McGriff. Is that the next one?
Oh, there's two gentlemen. I'm gonna find out their names in a second, Judge.
Okay.
Or if you
All
want me
right.
to find out, I can right now.
No, it doesn't matter. I'm just trying to get you out of there. Jacob, Jacoby, Eddie Jackson, please.
It was a KBS for the criminal.
Okay, you are charged with one count of operating without a valid DL, $25 bond. Count 2 is unlawful speed, which is basically a civil traffic infraction. It's ROR. Count 3 is criminal mischief over $1,000. Bond is set at $500. Any objection to probable cause?
I guess, is the criminal mischief a warrant? Okay, because I don't, oh, I see, it's a warrant, okay, I see, it's a warrant.
Yes, KP.
No objection to probable cause.
But that's not the operating too. Hold on. Okay, court's also going to find probable cause, Mr. Reedy, on operating without a valid driver's license. There's a uniform traffic citation that was issued. Okay. All right. So, anybody wish to be heard with regard to bond?
Yes, Judge, we're gonna be asking if, Jacoby Jackson can be released on pre-trial release. He's, on disability, 25 years old, been here whole life, living, with his brother. His brother is also on disability, so I don't think he'll be in a financial position to post his bond. So, Judge, before I go any further, I'll see if the state has any objection to that.
The state would have an objection to that. We would be asking for the normal bond amount based on the allegations of the case and no victim contact.
All right, the court is going to order no victim contact, direct or indirect. Can I have the victim's initials, please?
D. Victim's initials are DE.
Okay. Direct or indirect means no contact with DE means no in-person contact, calling, texting, writing, anything on social media or the like. Do you understand?
Yes, ma'am.
All right, the court is going to put you on standard pretrial release. You can't afford any bond?
No, ma'am.
Okay, ROR on 1, ROR on 3.
Okay, I'm gonna give you the location of pre-trial.
Mr. McLaurin, hi.
Good morning, Judge, again. Judge, I just wanted the court to be aware that Arthur Daniels, he's on page 16, you reset him for this afternoon. The count 1, which is the municipal ordinance, is a Hollywood municipal ordinance. It's not a Fort Lauderdale municipal ordinance. So unless there's something else, I probably won't be back on Mr. Daniels.
Oh, okay, thank you for letting us know. Thank you. All right, bronze of, oh, Mr. McLaurin, come up for a moment. Hold on. I'll have it.
You didn't?
Hold on.
Yeah.
Yes, right now we are. I can turn, not before. The number on the back. All right, Bronza Via McGriff.
Judge, there's one more person here, Eric Riggins.
Oh, I'm sorry.
So after you're done,
No, we can do that one. Who is it? Eric
Riggins?
Riggins? Sure.
On page 25, it's a violation of parole.
Oh, all right, no problem. All right, Eric Riggins, please, come on up. Okay, Mr. Briggins, good afternoon, sir. You have a violation of parole You are gonna be held no bond. You will be hearing from the parole board, okay? They'll be in contact with you. Who is that
And
other
Judge, the
gentleman?
last person here, I think, is the gentleman, Mr. Avon Riles. He's the gentleman that's waiting for his attorney, Mr. Bill Jelen.
Okay,
So,
all right.
okay, thank you.
So you don't have Powell, Polanco, or McGriff, right?
McGriff, I've been advised, is in regular court,
Okay,
North Wing, room 15385.
15385.
You would ask for a what?
Is that Judge, who's that? 15385.
He's out right now he has a pending case.
That could be
Oh,
a,
yeah.
I'm being advised. I've never,
all right, here you go, Willie. We can reset that for this afternoon.
reset to PM. Okay.
Yeah, we'll see if Willie can get them over here. And then we,
Mr. McGriff, reset for PM. McGriff?
all right, and then we have Michael Polanco Muniz. That's a medical reset. And then you have, do you have him? He should be at the end.
The last person on my docket was Bruce Hodgson. But we didn't.
Where's Michael Polanco Muniz? Do we know what page he is? 24, Mr. Romero.
Oh, 24.
He's a medical reset, okay?
Oh, North Broward.
He's a medical reset.
Yeah, Mr. Jelen would like to appear by phone, Judge.
All right, that's no problem. And Matthew Powell, what page is he?
25.
Page 25. Does anybody know where he? Bonded. All right.
What about Ferrara? We did? What did we do with him?
What did you call that term?
Oh, okay. I remember.
I couldn't hear you.
No, I know, because that was one of the cases that was called out of turn at the beginning of the document.
Oh, we called that out of turn in the beginning of the docket. All right, so I'll see you back at around 1 o'clock. We do our extraditions,
what
and
happened
then
with this
we do
what
your
happened?
cases,
What-
okay?
sorry, what happened again?
No, 1 o'clock. Well, I'm just letting you know, right after we begin at 1 o'clock. So 1:15 is 11:32.
I mean, we started around 2 and then we started around 1:30. So I don't know if it's just safe just to say 1:30.
Mr. Romero, I don't know about the time. All I can tell you is I'm saying I want everybody back here and ready to go at around 1 o'clock.
Your Honor,
Okay, you have time to talk to people.
did we call or were we advised what's going on with Danio de Oliveira Pereira? And if we did, I apologize, we missed it. These are all at the end, frankly.
Hold on.
Reset for the PM?
Someone's talking to us. Hold on.
He's already set for the Portuguese.
Oh, Portuguese interpreter,
Who's
okay.
talking? Who's talking about a Portuguese interpreter? Where are you?
Okay, so how do I do the
PM?
Okay.
Okay, thank you.
What are we doing with Mr. Rouse?
I'm gonna call Mr. Jelen right now.
Step up, sir.
It's Mr. Riles. Wait, hold on. I thought it was Trevon Riles.
It is.
Okay. All right, Mr., I need Jelen's number. Hold on, sir.
I wish you would have. Exactly.
Charge you better.
Bye.
Actually,
Thanks for your help.
Actually, because of where we are,
Yeah.
I would have charged that Leo.
You what?
Have her charge that Leo.
Oh my God.
You know that? If
What?
someone commits a battery against us,
On a prosecutor? Yeah. While you're in work. Yeah. That's crazy.
I'm okay with that.
Okay. Give me one moment, sir.
Brian.
Thank you.
It's not a well thought out plan.
It could be, depends on.
Yeah, yeah. But for weed, crack.
Did you give it to the other?
No, you're not having my car for weed.
Yes. You still got it? Okay. I just wanna make sure. Okay.
Yeah, really. It's 2018 Maserati. Gotta have it.
Yeah, this, I was talking to the detective. This
You want me to stay, Judge?
No, not at all.
I'm gonna get some lunch. I'll see you all this afternoon.
All right, see you then.
Always a pleasure, man.
Shall
This is like a 6-year-old Hispanic guy. He's like, I've never smoked weed. And I'm like, first of all, right? He's like, that's like, what kind of car is it? The whole trailer car for weed. Like, I've seen, we've had. But who the hell's like, I need some weed. Just take my car. Like, no one, I don't think we've ever had someone that was doing something like that. So take my car.
That's concerning.
All right, see you guys later.
See you.
Yeah,
Take-
especially no car that's been made in the past 20 years. But the detective was telling me that's what all the younger kids are doing these days when they're doing contact and they're.
Wait, someone has healthy lungs outside.
Oh, now I can hear you. Hi, this is
Traded
Michelle
for
from
her.
Jeff Molitor.
Also,
Wait, so what happened with the attempted murder one?
it's reset for the afternoon. He's in court. He's actually in court for determination of counsel.
Oh.
Oh.
All right, Mr. Jalen?
Yes, Judge.
Good afternoon,
No, he's
how
been
are
in
you?
custody for about a month.
Good, how are you?
Fine, thanks.
So why is it just?
I have a Trevon Riles who's at the main jail. It's my understanding you wish to appear by phone and you don't want us to reset this for the PM? It's up to you.
Yeah, if you want to, why don't we go ahead and set it for 1:30, is that okay?
Sure.
All right, great, I'll see you at 1:30.
All right, he'll be here at 1:30, okay? This way he can look at the paperwork. Thank you.
Yeah, thank you so much. Bye.
All right, bye-bye. All right, sir, see you then.
All righty.
Okay, it's actually gonna be around 1:15, sir, okay? Thank you.